Take o ngā kōrero te pānanga tīkina atura, te hautapu o ngā ariki kauwhatatia e tāne te pānanga ki runga ki mātau, ki e nei pūkenga, ki e nei ahorangi, ki e nei roia, ki e nei kai whakapā, ka whakamau kia tīna, hui e. Ka takina te kawa, ko te kawa nui, ko te kawa roa, ko te kawa whakatike, ko te kawa ia hua mai no tiki o te rangi. I te pū, ko te wehu, ko te rito, ko te take, ko te pūkenga, ko te wānanga, ko te taura, ko te tauira. Tēnei rā te āwhinuku, te āwhirangi, no te oro i o matua, i pue ia i te take ue nuku i ue rangi tēnei ka hoho ki runga ki te tupua, ki runga ki te tawhito, ki runga ki te kāhui o ngāriki. Kia putara mātau e nei, taura e nei, tauira ki te whaiau ki te ao mārama. Uhi wero, tau mai te Māori, haumi e, hui e, taiki e. Tēnei tātou te hui mai nei ki te whakanui ātara. I tēnei marama, i tēnei rā, ki te kōrero, i ngā kaupapa, ki te whakarongo i ngā kōrero mō te takutai moana, o tēnā iwi, o tēnā iwi, o tēnā iwi, o tēnā kaikereme, o tēnā kaikereme, o tēnā kaikereme, huri noa tō tātou motu, tō tātou whenua. E mihi ana kia koutou ki ngā kaikereme, kua tai mai nei koutou i tēnei rā, tēnei au te tiro ake nei, e kai konei koutou. E mihi ana kia koutou, kai te kita ki o koutou, te taitoke raupa, tai mai nei koutou, hei ngā rangatira, haere mai, haere mai, haere mai. Haere mai, me o tātou tini mate. O tātou tini mate, e hinga mai nei, e hinga atura. E harate nei i te taupai mō tātou mate. Ka nui, o tātou mate, ka ngaro, i tēnei tau o Matariki. Mo reira, ko rātau e rā, he wātōna, e tūtakitaki anō ai tātou ki o tātou mate ko i nei te pai, wā tātou tikana ka kite atu ia koutou, ka kite mai koutou, ka hui mai o tātou mate, ka whakaaro tātou mō rātau. Nō reira, e mihi ana kia koutou mauria mai ngā mate ko rātau kia rātau, ko tātou kia tātou. Haere mai koutou, hei ngā rangatira e kara. Pera hama tēnā koe, kua tai mai nei koe, kai tiki te atu i a koe, tai noa hoki ki ngā kai awhi i a koe, kua tai mai nei rātau i tēnei rā. E mihi ana kia koutou. Koutou ngā wahaki, ngā roia, ngā ringaringa, ngā waiwai o ngā kaikereme ko koutou e nei kai tiki te atu a koutou, ka mihi ka koutou, haere mai, haere mai, haere mai. Koutou te karauna. Tēnei te mihi ake nei kia koutou i tēnei rā. Me ngā kai, me o koutou ringaringa, me o koutou waiwai, kua tai mai nei koutou i tēnei rā. E mihi ana kia koutou, ko koutou rā, kai tēnā taha, ko te iwi, ko ngā kai kreme, kai te rā taha, ko tā mātau mahi, ko tā te ropu whakamana i te tiriti o Waitangi, he whakarongo ki ngā kōrero. He wānanga i ngā kōrero, he pātai i ngā pātai, me nā kāori te marama kia mātau. Me nā kāori te marama kia mātau ngā kōrero ngā kai kereme, me nā kāori te marama kia mātau ngā kōrero, a te karauna ka noho mātau ki te pātai. Nō reira, tēnei te mihi ake nei ka koutou, nau mai, tātou katoa, e hui nei tātou i tēnei rā. Tai noa hoki ki tātou ki te rōpū whakamana i te tiriti o Waitangi, te kai whakawā, mi haro tēnei te mihi ake nei kia koe, tainua kia koe, hei te ika whiro, Ron tātou. Ko tētahi o tātou, hei mōhiotanga hoki mā koutou, mā ngā roia, mā te karauna, ko tētahi o mātou, ko rāwinia, ko tākuta rāwinia Higgins, ka ore tai mai tēnei rā, kua hinga tana whaia kōka, e hoki ana ia ki te uhuna raiwa ko tana māma, ki te uhuna mō te tuahine o tana māma. Nō reira, kaore ia tai mai tēnei wā ko mātou. Ko te mate o mātou, he tāne katoa mātou, engari kau a tērā e noho hei hara mō mātou. Nā te wā tērā iki, e hara nā mātou iki, engari nā te wā. Nō reira, e mihi ana kia koutou, nau mai, haere mai, Tēnā koutou, kia ora tātou katoa. Arawa ki te whare, anaroa takahie, e whare o te kahi katoa, hei nau whakapai hei whakapai ururoa e hau mai nei, hei waho kei te moana, ka ore aku mihi aku tangi mō koutou, maupuku ko te iwi ka moai tonu te whenua e ka koto nei. Kua tātou tikanga kano hoa ke nei au, kua tuwhera ngā mihi. E kara ko koe te mea i haere tawhiti mai, kai a koe ngā mihi tuatahi. Ka tuku ki ngā roi, ka tuku ki te karauno me nā he kai kōrero rātau, ka mutu a koutou, ko hoki mai ki te kai whakawā, kua tīmata te haere o ngā mahi. Tēnā koutou, kia ora tātou katoa.
Taungi ana ki ngā tāngata. Koro hihi pō, koro hihi au, koro ngoi tūria ki te matahau atu, tū te wini, tū te wana, tū haka putai nei te whei au putātura ki te ao marama, ti he wā mauri ora. Ka mihi atura ki a koe kara, e tāpau, te kaihaka rite i tuku i te reo. E pākau atura ki te wahi ngaro e whitiki ngai, e nei whakahaerenga. Tēnei noho ngatahi ki ngā mānākitanga, o tira ki te wairua atawhai, e hua atu ai tā tātou waka. Ka mihi atu hoki ki a koe, mo ngā kupu mihi, e uwhia mai ki runga ki te hunga, kua hui atu nei. Nā reira hei ngā mema, o te tribunara tēnei rā, te ata mihi atu rā ki a koutou, hei te kai whakawā, miharo e mihi atu ana ki a koe. Ngā mana, ngā tapu, ngā ihi, ngā wehi, kua hui atu nei, ki te upoko o te ika, tēnei rā te ata mihi atu. Tatu ake rā ki te mana i te whenua o tēnei takiwā. Anei rā te reo o mihi. Hau ngāno mai a ngā tiwai anake, ngari ngā kai kreme e hui atu nei, a ki te aroaro o tēnei whakaminenga, e mihi atu ana ki a koutou katoa. Kore rā e mahu e te mihi ki o tātou aitua, ki o tātou mate. Oe rā kua whakahua maina, ka nui rā te tiko au a kōrero. Tēnei tau rā hoki, kāhia nei hautupua, kāhia nei tōtara, kāhia nei kauri haimata kua hinga. Nā reira ka mihia katoia mai hoki ngā mate kei runga i a mātou kia tūhonohono tia o tātou mate. Ko tahi rā te kōrero ki a rātou e o tātou mate haere mai haere. Whakarapa atu rā koutou ki te poho o te rangi. I a matariki i a tautoru, i a puangarua e māreo atu ana ki te pai. Ka tira e o tātou mate, haere koutou, haere koutou, haere koutou. Tēnei rā kua tae mai, ki te maumai a mātou naue, ki te maumai a mātou whakaaro. Kia whaarikitia ki te aroaro o tēnei hui ngā tāngata. Pākau ake rā ki te moana, ki te papatai moana. Te kupu ataku tupu nā manai a hakua tua nā hau ki uta e taupu ngāna ki tahi. Ko ngā mana katoa o ngā tiwai no te moana, no te papatai moana, no ngā tani whao te moana. O ti aku tupuna e rā kōrero te whaarikitia. O ti rā te haka toi roto i a mātou. Ko te moana rā ia e korohihi mai ana i te pō, e korohihi mai ana i te ao. E turuturu mai ana ki uta, e turuturu atu ana ki tai. Nā reira, tāku noa ki a tātou, ki au, ka mihi atu rā ki a tātou, te iti te rahi e hui hui atu nei huritu huri noa tēnā koutou kia ora tātou. Te toko toko I whenuku, te toko toko I wherangi, toki atu kia. Ko te mumu, ko te awha, ko te mani, kai o tā kiri pana kara, I runga kara, I raro ka whai tā more, I runga ka whai tā more, I raro. Tēnā ko te pau, orongo, norongo, mauri, ora ka Tēnei mea te mana tuku iho, e hara I te mana no nana hinoa nei, e hara I te mana I ahuma I te tiriti o Waitangi. He mana I ko paua ki tēnei whenua mai noi te hi ngāke a Māui tiki tiki a taranga, e here ki a tuana. Ngā uri whakaheke ki te ao wairua o tira ki te ao ngā tua. Tēnei mea te mana tuku iho, he taura tāngai e rena tonu ana. Huri tu huri noa tēnā koutou kia ora tātou.
Kei tanguranga tira, tika tonu rā ka kōrihia kei te pō ka kōrihia tu nei ki te ao. Tēnei tātou ka whakatūhia ki te matāhu o tēnei wā. Ia tūwai rā ko te ihi, kia tūwai rā ko te wehi, kia tūwai rā ko te wana. Kia tūtonu nei tātou kia whakaputahia atu ki te whai au ki te ao mārama, whiti, whano, tau mai rā ko te mauri a hauni e, hui e, tai ki e.
Poi, ia.
E tohu tēnā, mo ngā huatanga I roto I tō mātou whare. Anei, a te arawhiti, ko tei mai nei ki te whakakanuhi te krauna, I roto I tēnei kaupapa o tātou. I roto I e rā whakamāramatanga ka tautoko tonu atu, I te ia o ngā kupu, e aro atu ana ki ngā mate. Nā runga hoki I te mōhio, e hara I te mea ko tēnei rā noa nei, ngā huatanga e whakakōrero tia ana. Nō reira, e peni ana te kōrero e ngā mate, hoki wairua mai, whakalongo mai ki au moko puna. E whinina ki atu ana ki te tui, te raranga I ngā whakaaro, e tai ai e tātou, te huarahi ki uta, te para. Nō reira, kai taku pāpā, e po, te manu tāwhiorangi o te wā, tēnei e mihi atu nei. Kā mutu, ki ngā pai manu o te pai, e ahumai ana ki a tātou, e ui ana I a tātou I tēnei kaupapa nui. Ai, ui amai. Tui amai rā ngā kōrero e tai ai, ngā whakaro e rā kōrero, te tuku atu, hei au mārama, ki ngā minita o te wā. Nō reira, e arei te mea, kei te whakatoroa hia ngā kōrero engari, ko te whakatūtuki e nei tika ngā tātou, e keho ai te māramatanga kōai mā, kei roto I te whare nei, nō reira anei a te arawhiti, me ara hononga, kua roa nei e arawhiti ngia ana, nō reira kai akuranga tira o te taitoke rau, kā mutu, ko ngā whakaaro, ki ngā parikāranga huri noa I te motu, o tira ngā tai timu, ngā tai pari, ko te au moana tēnā e hono ana ki a tātā. Tēnei e mihi atu nei, tēnā koutou, a nei mata, o tira, tēnā tātou katoa.
Poi poi a te reo hei kura, poi poi a te tangata ki a mau o te reo Māori, hei taonga tuku iho mō ngā uri wakatipu e. Poi poi a te reo hei kura, poi poi a te tangata ki a mau o te reo Māori, hei taonga tuku iho mō au te aroa e.
Tauana. Ka tukuna atu te Māori, e hoki atu nei, koutou te pai, tēnā tātou.
Ha tēnā koutou. E tautoko ana au i ngā mihi kua mihi i tēnei ata, ngā mihi o te pāpā o ngā rangatira hoki Apirahama. Tēnā koe, he mihi hoki ki a koe e te rangatira, e te māngai o te karauna i tēnei ata. Ka nui te mihi, kia koutou katoa nau mai hoki mai ki tō rōpu whakamane te tiriti o Waitangi. Good morning. Just before I take appearances, just a couple of brief points. As you would have heard, unfortunately, Professor Higgins can't join us because of a mate. We do have a majority still on our panel though, so we will proceed and we will see how Professor Higgins goes, whether she may be able to join us at some stage. I'm also aware that we do have a very small space here. I have been told that for those who can't sit inside the whare here, we do have an overflow space on level 7 with seating and a screen there following the live stream. So if anyone is unable to get a seat in here, please make your way to level 7. But with that, I'll take appearances, please.
Ka mihi atu ki te whare atu nei, tēnā koe, ki ngā tangata whenua, tēnā koutou, tēnā koe, te rangatira, e te kai whakawā, tēnā ka mihi. Anō hokui ki a koutou nā mema o te rōpū whakamana e te tiriti o Waitangi, tēnā koutou. Lyle appearing with Ms. Wedland on behalf of Te Pukerehi Iwi, the Panaho Whānau and Te Rai Ahu Whenua Trust, ngā whānau hapu o te aitanga Hauati Takatau Moana, Ngāti Pirauki Hauraki and Te Rorua Iwi, Sir also appearing for Heta Koko on behalf of Te Rauhina Marae and Hapu, and William Tawiki on behalf of Ngāti Tamarangi, those last two being interested parties. Tēnā koe, Sir.
Kia ora, thank you, Mr. Lau. Ms. Wedland.
Tēnā koe te kai whakawā o tira, tēnā koutou e te pai whiriwhiri o te rōpū whakamana i te tiriti o Waitangi ko Ms. Tehira tōku ingoa no te tarituri o Annette Sykes & Co. Kei konei māua ko te roia Paumua, Miss Cole, e whakakanohi ana i ngā kreme Waitahi Rua Rima, he kreme tērā nā whae Angeline Greasehill mō te hapu o Tainui. Kei konei hoki māua ki te whakakanohi i te kreme Wai Toru Rima Whā, he kreme tērā nā Mata Arapita Hamilton, rāua ko Mararaia Hamilton mō te hapu o Ngāti Manu. Me ona pānga hoki ki roto o Ngāti Rongo, te uri rairewa me tahi atu no Ngāpuhi. Kei konei hoki māua ki te mātaki mā te hapu o Ngāti Ira o Waioika, kreme Wai Rima Rima Waru. Nā runga i te take kua here a rātau ki roto i ngā kōtitanga o te kōti Mananui. Nō reira, koira tā mātai tēnei ata e mihi ana kia koutou.
Tēnā korua. Thank you, Mr. Hira. Ms. Cole.
Tēnā koe te kai whakawā, mātua pau, tēnā koe, Mr. Crosby, tēnā koe, mātua apirahama, tēnā koe, me te mana moana, tēnā koutou, Ms. Black with Ms. Ehrlich today, appearing for te whānau moana me te rorohuri. Tēnā koe.
Tēnā korua.
Tēnā koe te kai whakawā, koutou hoki te rōpū whakamana te tiriti. Tēnā koutou, kei konei māua ko Kelly Dixon, māua ko Ms. Talamai Vau, mō ngā kreme Y745, the Patu Haraki ki te Iwi Trust Board claim, Y2764, the claim on behalf of the Ngāti Wai Trust Board, and also registering the appearance for Y2726, interested party Mr. Keatley Hopkins for the Ngunguru Marae Trust. Kia ora tātou.
Tēnā korua. Thank you.
Tēnā e te kai whakawā o tira e te rōpū whakamana i te tiriti o Waitangi. E rere ana ngā mihi kia koutou. Kua tai mai nei, kua whakarite i tēnei nohoanga o tātou i tēnei wiki. Ka te tautoko ana i ngā mihi ki o tātou mate o te wā. Haere atu rā. O tira ki ngā kai kreme kua tai mai i tēnei wiki. E rere tonu ana ngā mihi kia rātou kua tai tawhiti mai i tēnei wā. Kia tātou te hunga ora, kua hui mai nei i runga i te karanga o te kaupapa e mihi ana. Tēnei te kai whakawā ko Ms. Heroini tōku ingoa. Ko tai mai māua ko Ms. Evans no te tari o kaupare lo. Ki te whakakanohi ngā kreme e toru, tētahi ko Ngāti Rehia, wai tahi toru whātahi, tētahi anō ko Ngāti Tamai Nupo, wai rua ono iwa tahi, me tētahi anō ko ngā karanga hapu o ngai te hapu, wai rua whetu, kore whetu, e mihi ana i te kai whakawā.
Tēnā korua.
Tēnā koe te kai whakawā ko Mr. Lars Thompson toku ingoa. No te tari o Phoenix Law, I appear today alongside my learned senior, Miss Mason, who is attending this morning over AVL, but shall be available in person from this afternoon. We represent a number of claimants in the inquiry. Mane Grant Tahere and the Ngāpui Runanga, Y3401. Louisa Collier, on behalf of herself, Ngāti Kawau, Te Koroa, Te Ure o Te Aho, and Ngāti Kuri, Y1524. Michelle Marino, on behalf of themselves, their whānau and hapu, and Ngāti Tama Te Kea Trust, Y377. Sailor Morgan and Francis Galton, on behalf of themselves, their whānau, and the Ngāti Rumahai Hapu and Ngāpui Whangaroa, Y1846. Joseph Kingi, on behalf of himself and Wiramu Abraham and Ngāpui Nui Tonu, Y1941. Turoma Remus Kawati, Rhonda Aurangi Kawati, and Michelle Jessup, on behalf of Kawati Marae Committee, Kawati Whānau and their descendants of Ngāti Hine, Y120. Apihaka Mac, on behalf of the Ngāti Tumangatai Kapiti, Y1018. Jane Mehirangi Ruka, on behalf of the Grandmother Council of the Waitaha Nation, Y1940. Eve and Peter Vaughan, on behalf of their whānau and the tupuna of Te Iwitahi, as part of Ngāpui Nui Tonu, Y3406. Matutera Tinana Clendon, on behalf of Ngāti Kuta ki te Rāwhiti, Y1307. And Rihari Richard Dargaville, on behalf of the Te Takaro District Māori Council, Y2661, and Evelyn Rasima on behalf of the Māori communities in the district which he represents, Y3399, as well as finally Morangi Potiki on behalf of herself, her whānau, and the Runanga o Ngāti Whakawe, which we understand that a Y is still awaiting registration. Just before I finish, Your Honour, just a small procedural matter in relation to this afternoon. There were some changes to the timetable in relation to some of our witnesses' appearances. Mr. Clendon and Mr. Tahiri, unfortunately, have not been able to arrange for flights to be able to be here in person for this afternoon, and consequently they seek leave to be able to answer questions via AVL this afternoon, Your Honour. Tēnā koe.
Thank you, Mr. Thompson.
E aku rangatira e te pai o te rōpū whakamana I te tiriti o Waitangi tēnā koutou. E te tā I o whakaro rangatira kua whakatūwhera tā tātou nei rā tēnā koe, o tira tēnā hoki koe Ngāti Wai a pera hama mō whakaro I a tātou tēnā hoki koe. Me mihi ka tika hoki ki ngā mate o te wā, te mate o te ata nei, tētahi o ngā pau o tātou, tētahi māraikura o te kohanga reo o te reo, tēnei ka mihi au ki a tūhoe whānui ki a rātou mā. Ko hori ana Uanis Taupe tōku ingoa, kei konei māua ko Ms Douglas, mō te runanga o ngā tiawa, interested party, members of the tribunal, e te kai whakawā. I also have a procedural matter, sir, but I'll raise that after appearances. Tēnā koutou.
Thank you.
Tēnā koe te kai whakawā. Hoki anō tēnā koutou te rōpū whakamana I te tiriti o Waitangi. Ko Michael Sharper Ho, appearing for Y3402, which is a claim by Kirirata on behalf of Nahapu of Ngāti Wai. Tēnā koutou.
Thank you, Mr. Sharp.
Tuatahi e mehi ana ki te whare e tūmai nei, tūmai rā. Ki te taumata I whakatūwhera mai te ara keimua, papa, matua apira hama, e mehi ana ki a koutou, nā tō mahi a tēnei ata. Hokli tōku ingoa e te kai whakawā, e whakakanohi ana au ngā tono e rua, te whakapiko, me te rewha rawa ko te rau iriwiti whānau. Tēnā koe.
Tēnā koutou I ngā mea mō te rōpū whakamana te tiriti o Waitangi. Ngā mai ki ngā iwi hapu katoa o te takatai moana. Ko Benyon maua ko Kudrat mō ngā kremi o Moipoko Tribal Authority Y3383. Tēnā koutou.
Tēnā korua.
Tēnā koe e te kai whakua o te rakia koutou katoa e hui hui mai nei I roto I tēnei kaupapa. E te kai whakua ko Ms Jackson tōku ingoa kei konei māua ko Ms Jamison no te tari o Tuku Law. We're representing claims from Te Kaputai, Ngāti Hine, Ngāti Hawa, Te Aupori and Te Whare ke Ngātai Kāwhia. Nā reira, tēnā koutou katoa.
Kia ora.
Tēnā koe te kai whakawā. O tira, tēnā koutou ngā rangatira o te tēpū, te rōpū whakamana I te tiriti o Waitangi. E mihi ana ki a koutou ki ngā kai kōrero I tēnei ata. Ka nui te mihi ki a koutou ngā kai kirime I tēnei whare, me kai kirime ki runga I te ipurangi I tēnei wiki. E ngā roia, e ngā kaimahi mā tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko Rock Soriano tōku ingoa, he roia hau nā te tari o Māori Horner Lawyers, He whakakanohi o mō kereme toru me interested party tahi. That's Y972, a claim by Don Tate on behalf of Ngāti Kauwhata ki te Tonga. Y1312, a claim by Bill Hori and Hinemoa Pourewa on behalf of the descendants of Whakaki and Te Hapu o Ngāti Kawo. And Y2389, a claim by Tahua Murray and Kawhina Paul on behalf of Ngāti Rōmahui. And our interested party is Y1843, which is a claim by Terry Tauroa on behalf of the Te Aito Hapu. Mauri ora e te whare.
Tēnā koe.
E te kai whakawā, tēnā koe. E te rapu whakamane te tiriti o Waitangi, tēnā koutou. O tira i nā mana whenua, i nā rangatira kua tai mai ki tēnei hui hui e te atanei. Me te hungi katoa e matakitaki ana, tēnā koutou. Ko Mr. Clapworthy, toku ingoa. No te matalo, te tari. Kika nei ahe ahau mō nā toru kareme. Ko te kareme tono nama nā Y1501/2612 mō Ngāti Te Wehi. Me Y420 mō George Ngatiami Matthews. Me Y2797 mō te rangi kaiwhiria Kemara, anō hoki. E rere ana nā mihi kia koutou. Kia ora.
Tēnā koe.
Tēnā koe kai whakawā me te tepu, ko Linda Thornton Aho. I'm here today on behalf of Y2581, a claim by Ani Taniwha on behalf of Ngāti Kawa, Ngāti Haiti, Te Urio Te Pona, and other whangaroa hapu. And Y3379, and claim by Fletcher Beasley and Kelly Klink on behalf of Ngāti Rehua, Ngāti Waiki Aotea. Thank you, sir.
Thank you, Ms. Thornton.
Tēnā koe te kai whakawā. Tēnā koutou i ngā te ropu whakamane te tiriti. Ko i vrongo tēnei, he roi ahau mō Y2188. Kānehi hapu o ngā ruahine iwi, ko Y2582 hōtere whānau. Kia ora.
Kia ora.
E te kai whakawā, me koutou o te tribunara, ngā roia mō te karauna, ngā roia mō ngā kai kreme, koutou ngā kai kreme, huri noa ki te whare, tēnā koutou, tēnā koutou, tēnā koutou katoa. May it please the tribunal, counsel's name is Miss Johns, and I appear on behalf of Tamaki Legal alongside my learned friend Mr. McMaster and my learned senior Mr. Naden, who is appearing via AVL. We represent 5 claimants in this stage of the inquiry. Y2776, Michael Williams on behalf of himself and Nai Tūpango. Y2787, Robert Gable on behalf of himself and Ngāti Tara. Y2788, Violet Walker on behalf of herself and Te Whānau o Rataroa. Y2789, Reuben Porter and others on behalf of Te Iwi o Te Raroa ki Ahipara. And finally Y2786, Rebecca Harper on behalf of the Perere Whānau. Your Honour, Mr. Naden intended to appear in person today but is unwell, so he will be appearing via AVL for the course of this hearing. He has prepared opening submissions and intends to present those via AVL and also question Ms. Marsh via AVL. We did advise the registrar of this last night, but seek leave if that's required.
Thank you. I am.
E te kai whakawā, tēnā koe, e te ropu whakamane o te tiriti o Waitangi, me nā kaimahi, tēnā koutou. Tēnei te mihi ki te mana whenua o te takiwā nei o te whanganui a Tara, arā ko te Atiawa, Taranā ki whānui ki te ōpuku o te ika, me Ngāti tō rangatira tēnā koutou. E nā kai kirime tēnā koutou, ko Stevens tōku ingoa, ke kone mātou, ko Ms McCoy, ko Ms Hussein mō te Corona. Kua tai mai mātou ki te tōtoko I te kaupapa o tēnei rā. Nō reira, tēnā tātou katoa.
Kia ora, Mr. Stevens. Well, thank you, Council, for those appearances. Do we have any preliminary matters that we need to address?
Sir, I have one matter, and then I'll pass to my learned friend. Dr. Panaho is scheduled to present or be questioned first on the timetable. The best laid plans, her flight from Whangarei this morning was delayed by 4 hours. So she's driven to Auckland and is taking the next available plane to Wellington, and we're hopeful she'll be here at around 11:30. So if she hasn't arrived but we're ready to start, I'll need to speak with my learned friends about shuffling the order to make sure that we use the time. We'll do our best, Your Honour.
Thank you.
Sir, it's Ms. Mason here. There are some AVL appearances that haven't been provided. Mine have, but there are others online, sir. Thank you. And also, it's very difficult to hear the speakers.
Okay, thank you, Ms. Mason. Yes, are there further appearances?
Tēnā koe te kaiwhakawā, tēnā koutou I ngā mema o te rōpū whakamana o te tiriti o Waitangi, tēnā koutou katoa. Council's name is Rawari. I appear on behalf of 7 interested parties in this inquiry. Those are Angitu Maira Trust, Ngāti Whakamaru Rangitainui, Ngāti Taratokunui Trust, Te Whānau Aroa Taupare, Te Runanga o Ngāti Mahuta, Ngā Hapu o Moko Kirunga, and Wairingaringa A Incorporation. I also note that Mrs. Siliano will appear with me online later this afternoon, and she will appear in person tomorrow to lead the evidence of Mr. Chris. Tēnā koutou.
Thank you, Mr. Rawari.
Tēnā koe e te kaiwhakawā me te traipūnara, ko Sabori me Ms. Nāpōna Roya, mō Ms. Meripika Raukawa Tate, Y3314 as an interested party. Sir, as Council is not actively participating in this hearing, and with your leave, Council will depart Zoom following appearances and participate via the live stream. Tēnā koutou.
Thank you, Mr. Sabori.
Tēnā koe katoa, Your Honour. Council name is Dr. Rekha Arya from Afiaki Chambers. Mr. Tawaki Afiaki is attending MACA hearing in Whangarei. And we are appearing on behalf of Waimaria Kingi and her hapu Ngāti Kahu o Torunare. And our claim numbers are Y619/2660. Tēnā koe.
Thank you, Dr. Arya. Do we have any further online appearances?
Oh, aroha mai, Your Honour. We are appearing as an interested party.
Thank you. No further appearances? Are there any further preliminary matters that we need to address?
Yes, Your Honour. Excuse me, it's Mr. Naden here. Tēnā koe, me te tēpu tēnā koutou, tērā koutou katoa tēnā koe. Your Honour, in relation to the summons application, which was dismissed last Friday, there are some reasons on their way, excuse me, sir, on their way, and I was just wondering if I may the estimated time of arrival, Your Honour, in relation to the reasons.
I can't give you an exact time frame, Mr. Naden, but it will be this week.
Thank you, sir.
Tēnā no, sir. I'm just wondering, do you have the hard copy of the timetable in front of you? I just find that when we're doing that kapai. I was in touch with the registrar early on Friday evening. Mr. Araroa, who ultimately found himself in the timetable at 2 o'clock today, had made arrangements with Aropu, my Te Rohe o Ngātiawa, to come down Tuesday morning. I've liaised with my friends from Te Mata Law, and they have agreed that Mr. Matthews, who was due to present at 9:35 tomorrow morning, he is available to present today at 2 p.m, where Mr. Araroa was originally scheduled, and if Your Honour pleases, that's how we'd like to proceed today.
Yes, thank you, Ms. Iwanistope. I have been advised of that change.
Thank you, sir.
Any further preliminary matters? Mr. Lyle.
Tēnā koe, sir. I think we start with openings in that case. I have sent a list to the registrar this morning of the order that Claimant Council have landed on. We've done our best to align the themes so that you won't be hearing repetition. And given where we are, sir, I anticipate that all council will be speaking to a summary of their opening submissions rather than running through the detail. So, sir, our opening submission was filed jointly for the claimants that we represent. It's document 3.3.12. And this morning I've filed a roadmap for presentation of those opening submissions, which I hope has found its way to the members and is on the screen now, I see. So the starting point for the claimants that we represent, who are listed in our opening submissions, and I'll come back to when I discuss evidence, is that the status quo is prejudicial. So were the Crown to do nothing and leave the Marine and Coastal Area Act in place as it currently stands, the claimants are prejudiced, and that aligns with the findings and that this tribunal has already made. That report came out near the end of last year, and the Crown has failed to respond to that report. Well, I was going to say whatsoever, but in the Crown opening submissions, it's noted that the Crown considers that the Act reasonably balances Māori and public interests in the Takutai Moana, and we see that could potentially be the first response to the report that was issued, and that would constitute well, really ignoring all of the findings and recommendations in that report in favour of the status quo, and then moving in the opposite direction with the amendments that the Crown seeks to make. We say that an honourable Crown would have acted with urgency to engage with applicants and all in Te Ao Māori to implement the suite of recommendations in the Stage 2 report, and then worked with Māori to develop a regime which is compliant with Te Tiriti. Now, sir, the proposed amendments I've set out at my section 2 of the roadmap, and I do think it's worth keeping those in mind, because while this was framed as a change to section 58 to respond to the Court of Appeal's decision in the coalition agreement, now that we have detail of the proposed amendments, they're indeed far broader than that. The Crown, we say, intends to unilaterally and radically amend the Marine and Coastal Area Act with retrospective effect to the 25th of July by inserting a declaratory statement into the Act, which will not only overturn the reasoning of the Court of Appeal decision that's mentioned in the coalition agreement, but also the High Court in Re Edwards Whakatohia and all High Court decisions since that have relied on that reasoning relating to the test for customary marine title. The amendments will add text to section 58 of the text to provide for the first time a statutory definition of the terms exclusive use and occupation and substantial interruption. The amendments seek to amend section 106, which is the burden of proof section, to require applicant groups to prove exclusive use and occupation from 1840 to the present day. And the amendments seek to amend the preamble, the purpose section, the Treaty of Waitangi section, and the customary marine title test. I'm going to come back to the detail of those amendments, but first I'd like to discuss the way in which these amendments have been framed. I'm on page 2 of my roadmap now, sir. Really, I'd like to highlight 2 points when I discuss the framing of the amendments. The first concerns this notion of equal citizenship, and the second concerns this notion of clarification of the test or a return to Parliament's intent. So the concept of equal citizenship, and this is from paragraph 25 of my opening submissions, these amendments are framed as being required or necessary to restore the principle of equal citizenship. However, we say that assumes that all citizens are equal to begin with, and that doesn't reflect the lived reality in Aotearoa, New Zealand today. The Waitangi Tribunal many times now has commented on this, and I haven't gone and dug out all of those quotes because my submissions would have been far longer, but suffice to say that the recent Matapono Waitangi Tribunal report pulls those materials together and says that to state that the amendments proposed in the coalition agreement to reverse measures which have eroded equal citizenship is to misunderstand the true balance of equality and inequality in Aotearoa, New Zealand, as the equal citizenship promised in Article 3 has not yet been fulfilled. So, in summary on that point, we say that the Marine and Coastal Area Act and the rights that it provides for do not create division or inequality. They're aimed at remedying it. Now, the second point I wish to highlight is this idea of restoring parliamentary intent, or that clarification of the tests is necessary. We say that the language used by the Crown in framing these amendments doesn't reflect the true scope of the changes proposed, nor is there a clear and compelling policy rationale for the amendments. At my paragraph 31 of opening submissions, we point to advice provided by the Legislation Design and Advisory Committee, or LDAC, which was one of the documents which was found by Mr. Keith to be worthy of unredaction in his independent review process. And they addressed the this policy and rationale for the bill, the idea that it's required to clarify parliamentary intent and say that it's not a helpful articulation of the policy objective, that the correct avenue to challenge what the law is and what Parliament's intent was is an appeal to the Supreme Court, and that legislating in this way does not restore Parliament's intent, it changes the law as it currently exists. So the claimants ask what is really motivating these changes. One motivation does appear a concern that recognition of the of customary marine title over what the Crown may have, or may consider as a larger portion of the CMCA than it previously anticipated, may challenge, in quotes, New Zealanders' expectation of having an equal say over the management and use of the coastline. How New Zealanders' expectations are measured is not addressed in any of the documents that we've seen, and it appears to derive purely from the minds of ministers. We also say, and it's concerning that, this also assumes that Māori do not have the same stake in the economic and environmental well-being of Aotearoa as every other New Zealander. And that view is simply not borne out on the evidence that we do have from the Crown. As the briefing paper which was provided when we filed these applications for urgency some months ago, created by Lil Anderson for Te Arawhiti, noted concerning the fast-track consenting bill, and I'm at my paragraph 37, there's sometimes a misperception that Māori involvement in consenting processes is always likely to be obstructive and contributes to delays and high costs for those seeking consent. Recent experience demonstrates that any perception that Māori involvement in consenting is always an obstacle is unfounded. So I'll just say that when you do look at the evidence filed for Te Pukereke Iwi, there's an affidavit there from Christine Martin who discusses this difference between all New Zealanders and Māori and that differentiation, and notes that she doesn't see that there's a real reason to amend the MACA Act except to further entrench Māori as second-class citizens whose property rights are not respected even under a political and neoliberal economic system that prioritises property. Now, sir, in our opening submissions, which I should say are fuller than they probably normally would be, but we decided that it was appropriate to file a fairly full submission as an opening given the urgency here, and then in closing probably to be more brief and targeted on the issues that have arisen over the course of the week. So we've addressed the te tiriti principles, which we say are engaged in some detail as a part of those submissions. The one that I did wish to focus in on today is tēnā rangatiratanga. This tribunal in your previous report has already said that any reduction of legal rights in Te Takatoa Moana corresponds to a reduction in the claimant's ability to exercise tēnā rangatiratanga. And that recent Matapono report concluded that rangatiratanga can limit the Crown's right to govern. Now, the claimants say that that finding has been met with some controversy, but it's not controversial in and of itself. It's something that this tribunal, or the Waitangi Tribunal, has been saying for many years now. And in preparing for today, I had occasion to look back at the ministerial review document and was also reminded of the inquiry that was held into Te Turu Whenua reforms quite a few years ago now. And this is a clear and consistent message that the Crown has been getting over the years, is that where Māori interests are squarely before or squarely concerned in the decision being made, then engagement is required, and depending on that interest, consent may need to be sought. It's concerning that we're getting on to a generation of the Crown being told that now, and it seems to be falling on deaf ears. So on that, and to be very clear, the claimants do challenge the Crown's constitutional right to make these amendments without consultation. So we also have a section on the on UNDRIP and the New Zealand Bill of Rights Act, which are set out in my opening submissions in some detail, and I won't cover them on my feet today, but am happy to answer any questions that you may have. That takes me to consultation and engagement. Now, I've already mentioned about the sliding scale of the Māori interest, but I think it's fairly clear that the Takatau Moana, if it wasn't already, is at the highest end of that scale. And yet we have the Crown in its opening submissions, I think, making an acknowledgement, we might call it a concession, that the applicants under the Act were not consulted, and that's at their paragraph 21, prior to the 25th of July. We say that that doesn't go far enough. It's not just applicants under this Act that needed to be consulted, but all Māori who have an interest in Te Takutai Moana, all who participate in Te Ao Māori share that interest, not just those that have either filed applications under the Act or have instructed those representatives to file under the Act. Further, we say the limited feedback window cannot constitute even the barest of consultation or engagement in these circumstances. Applicants were presented with a fait accompli, for want of a better expression here, and asked to provide feedback on some terms, perhaps have some input into the way that the overall amendments land, but the broad structure of the amendments had been decided. The concrete had already dried on those. And in some ways, the idea of asking applicants to make comment on how the terms exclusivity or substantial interruption is prejudicial in and of itself. In effect, they're being asked to help to define terms which will prevent them from obtaining title. We also say, and I'll come back to this, that being asked to define substantial interruption in circumstances where the Waitangi Tribunal has already recommended that that term should be removed from the Act, ignores the Waitangi Tribunal and is prejudicial in and of itself. A learned friend, Mr. Benyon, in particular, is going to take you to the hui that was held between ministers and the seafood industry representatives, so I'm not going to dwell on the detail of that hui today, but I would just note, as we have in our opening submissions, that there we have two ministers, Te Arawhiti staff, meeting with the seafood industry representatives and their council at a hui on 21 May. And there we have the ministers making some very frank statements, as I'll come back to soon, about the reasons that they wish to make these changes. But then the next day, the minister attends a hui with Ngāti Koata and sings a very different tune. We move from the Act must change to the Crown is committed to acting in good faith over the course of 24 hours. We say that that actively prevented the minister from receiving informed comment or kōrero on the proposed changes, because the scale, extent of the changes and the timeframes was being hidden from all Māori, not just applicants. Now, sir, at my part 5 of my roadmap, I've entitled it A Test That Isn't Intended to Be Met, and some may push back on that, but we say that that is what is intended here. If the intent is to set the test in a way that only 1 to 5% of the entire coastline is able to be granted customary marine title, well, that's an impossible task. you can't go and survey the entire coastline, work out the germane features to work out how the most remote of Māori whenua, the common features they have, and then say we're going to set the test so that only those 1% or 5% are captured. The best that can be done is to set a test and then leave it to the courts to interpret that test, as has been done under the Marine and Coastal Area Act. And we say that having done that once, now the Crown seeks to provide the narrowest possible test to restrict the court as much as they can. And the way that they seek to do that is creating a test that just doesn't work. It also asks far too much of applicants, given the balance in the Act. They're asked to provide, in effect, evidence that they've kept their rohi under lock and key from 1840 to the present day. The Minister makes a note about presumably they would have a navy to enforce the 12 nautical mile limit. And in return for this, they receive rights that if they did hold their area under lock and key, they would already have. They'd already be able to prevent people from applying for resource consents in an area in which no one may go. But of course that's just not the lived reality. People do have rights of navigation. People are allowed on the beaches, despite what some of the worst in society say. Iwi authorities aren't down at the beach collecting tolls. That just doesn't reflect what actually goes on the ground. But that's what would be required under the Crown's proposal. To address parliamentary intent, and I'm aware the clock is ticking, Your Honour, the claimants say that while the term parliamentary intent is in the coalition agreement, it hasn't really been what's on the Minister's mind. It's that idea to create a test which is restrictive as possible, and which aligns really more closely with that under the Foreshore and Seabed Act. And then there's also the plain fact, as LDAC agreed, that the amendments can't restore parliamentary intent in any case. It can only change the law. So, sir, others are going to cover this off in more detail, so by way of very broad brushstrokes, the way in which parliamentary intent was assessed seems to have been that Te Arawhiti provided some initial advice in December and then scurried off and undertook a task of reviewing available documents to try to work out what was in Parliament's mind at the time the Act was passed. And so I've got some large copies of this that I might pass up if I may, to make things easier. As I understand, some of my learned friends will also be referring to this table, but thank you. So here we have a table which is at TA 003.0044. On the left-hand side of that table, we have really what the long and short of the Te Arawhiti view of parliamentary intent was. We've got establish a principled approach to testing customary interests, not based on predetermined outcomes. Well, that's fairly non-controversial. Address some criticisms of the 2004 Act's test, e.g. the requirement for ownership of abutting land, incorporating tikanga, etc., which seems a touch dismissive, and we'd consider that some criticisms of the 2004 Act somewhat reads down the stain that that Act made on all of society in Aotearoa at the time. Drawing from international common law and New Zealand's legal heritage, and then create an exacting standard, brackets, exclusive use and occupation, that aligns with the proprietary nature of customary title. And finally there, provide for recognition of unrecognised extant property rights, rather than address historical grievances. So we have those 5 points, and then a 6th is added slightly later in the stage, which we've reproduced at 94 of our submissions, which is recorded as Parliament intended to ensure the additional sets of rights be available to only those groups with strong customary connections to the marine and coastal area, reflected in exclusive use and occupation of the area since 1840. Now, all of this, sir, is to say that the parliamentary intent as recorded seems engineered to manufacture an outcome. These are all targeted at the first purpose in the Marine and Coastal Area Act, establish a durable scheme to ensure the protection of the legitimate interests of all New Zealanders in the marine and coastal area of New Zealand, but we don't see the other purposes mentioned here or given expression here. Where is recognise the mana tuku iho exercised in the marine and coastal area by iwi hapu and whānau as tangata whenua? Where is that Parliament intended to provide for the exercise of customary interests in the CMCA or to acknowledge the Treaty of Waitangi? On this advice, that's not presented to the Minister, and we would say that this advice is, if not misleading, has the hallmarks of that. I should note on that first purpose, to establish a durable scheme to ensure the protection of legitimate rights, His Honour Justice Churchman, I think, rightly commented in the Redwoods Whakatohia High Court decision at paragraph 129 that in order for the scheme to be durable, it must also be workable and applicants must be able to gain recognition of their title. So that purpose isn't all one way either. Here we also say that Section 7, the Treaty of Waitangi section, shows Parliament's intent, and that isn't given any mention here. Parliament clearly under that section intended to promote the exercise of customary interests of Māori. Well, that's not on the documents that we have. That wasn't presented to the Minister as being what Parliament intended. And that's wrong. We also say that it's startling that nobody seems to have gone to the decisions of the courts to see what the courts thought Parliament intended, and that's the court's function, is to work through those questions. We've set this out more fully in opening, but I did want to take the panel to the Court of Appeal decision, particularly paragraph 426, because we say that grounding the test in Western proprietorial concepts, as the proposed amendments will do, requires applicants to provide evidence not only, as I've said, that goes far and beyond the rights that are available under the Marine and Coastal Area Act, but which in many instances requires them to provide evidence of things which haven't been able to be legally recognised or available post-colonisation. The Court of Appeal was alive to that and said that the Section 58 test needs to have regard to, quote, the substantial disruption to the operation of tikanga that resulted from the Crown's exercise of kāwanatanga, and having regard to the scheme and purpose of MACA. And they listed relevant factors in a non-exhaustive way at paragraph 426, which I won't work through, but would respectfully invite the tribunal's attention to. We don't take any issue with those factors, but it doesn't appear that any of those factors have been given weight in the Crown's process to date, which really shows, when we go back to equality, that the impact of colonisation is being ignored in this amendment process. So all of that to say, sir, that the game is, as we say, very much given away when the proposed amendments include the preamble, the purpose, the Treaty of Waitangi, and the customary marine title test section. This isn't a restoration to intent. This is a rebrand and rebalance of the Act in its entirety. Now, sir, in our submissions, and I'll run through these briefly, we make comment on the declaratory statement that's proposed, the way that it will create uncertainty, the way that it includes High Court decisions which were not appealed at the time that they were issued by the Crown. They've sat on the record for years now and were only added at the last minute in April 2024. We also say that the Parliamentary Privilege Act has been used as an example where declaratory statements are concerned, but that Act explicitly did not change live proceedings. And I think a letter from the New Zealand Law Society has been filed as a part of one of the bundles accompanying opening submissions, and they make the same point there. And I'd invite your attention to that letter on that point. That runs into the retrospective application that these changes are being given to 25 July 2024. Your Honour, maybe being played off. We say that the justifications given for retrospective application of these changes are insufficient to justify going against long-established principles of the rule of law and the Legislation Act itself and creating a statute which will have retrospective effect. We also say that it's simply not necessary if we look to the Wairarapa decision of Justice Gwynne. Te Arawhiti's advice on that was it wasn't clear to what extent the Court of Appeal's interpretation even affected that outcome. So they're rushing to change an act in response to a Court of Appeal decision which may have just arrived at the same outcome in any case. And we say that goes to the bad faith in which these changes are being made. The decision also goes against Te Arawhiti's advice where they recommended against retrospective effect, noting the specific tidity context of the Act and the well-established norms and conventions around retrospectivity. We also say there's some perverse outcomes both procedurally and constitutionally where retrospectivity is put into effect, or drawing that line in the sand at 25 July is put into practice. So for Te Pukerehi and other applicants involved in the Re Edwards Whakatohia litigation, on the information we have, and this is still uncertain, so applicants are still confused, bewildered, and probably very frustrated is a mild way of putting it. It looks as though they are now going to be going to the Supreme Court in November for 2 weeks to have their appeals heard, and the Crown's appeal will be heard alongside those. The Supreme Court will in time issue a decision. That decision on the Crown's approach will have no precedential effect over all other applicants apart from those that are on the pre-25 July MACA. And then that will be remitted to the High Court, who will make another decision based on the Supreme Court's decision, which may then go to the Court of Appeal. So we're establishing this whole legal track, which will only apply to those applications like those applicants, those involved in Re Ngati Pahuera, those involved in Ngā Pōtaki, should that, actually that one I don't believe has been appealed, but Tukumarawa Ko and others. There's a parallel legal track that's going to be created, which is going to have to be worked through for several years now in order to achieve certainty and have those orders granted. And that assumes that when the Supreme Court sends it back to the High Court, the Crown doesn't require that or doesn't make the changes apply retrospectively, so that when they hit the High Court again, they're back to zero and the new Act applies. We just don't have certainty on that at the moment. For those post that 25 July line, even those in hearings such as Whangarei Harbour or the Kapiti Coast, which have had their hearing, Kapiti Coast still has some closing submissions and Puking evidence to test, but they are, for all intents and purposes, finished with the hearing part of their application and are awaiting judgments, but they're caught in the position of having to potentially go back to scratch and have a rehearing. It may be that some of the factual findings in the decision don't need to be changed, so there may be less scope to the hearing. We're not sure, but there doesn't seem to be a policy rationale which would justify putting those applicants through the time and expense of having their applications reheard. And for those that have lined up hearings going out right into 2026 is how far the court is planning at the moment. They don't know what law they'll be arguing at the moment. So, I mean, the uncertainty involved is prejudicial. And this is an area where the administrative convenience in holding the hearing here on the proposed changes and then hearing funding later really cuts across the claims in a way which is difficult for us as council and for the claimants, because the changes to the law and the funding, as you'll hear in the next hearing, really work hand in hand to hobble applicants to allow the Crown to make the changes that it wishes to make in a unilateral way, and then allow claimants to pursue orders if they then wish to, on the basis of reduced and capped funding. But we'll return to those issues at the next hearing. The last two changes are that exclusive use and occupation and substantial interruption will be defined, and at the beginning of my opening I addressed you on those terms and the fact that substantial interruption would have been removed by an honourable Crown, but that hasn't been the case. And finally, section 106, which this tribunal in your report last year found was not a breach of the principle of good government. We say that that finding relied on two assumptions: one, that substantial interruption would be removed from the Act, and two, that exclusivity would be viewed through a lens of tikanga. Should these changes go ahead, we say that that finding needs to be revisited, because section 106, on the information that we have, we say would be in breach of the principle of good government. So one note on prejudice. In the Crown's opening submissions, they state that it's too early to identify the extent of any prejudice, and really that needs to await the changes that are being made so that we can have a tot up and see what prejudice has been caused. I do note that they don't say that there will be no prejudice, but the claimants are suffering prejudice now, and the Crown's position seems to ignore that. Doing nothing prejudices claimants, but quite aside from that, the changes and the discussion around them that's been fostered. One example's been filed of the New Zealand Herald advertisement, which isn't a Crown advertisement, and we accept that, but this is the type of discussion and misinformation that the Crown's narrative enables. It foments division and racism. We also say the Crown has done little in the public space to correct that rhetoric and misinformation, and that is something that's within the Crown's control. They can't stop the New Zealand Herald from taking money to publish this type of what we say is misinformation, but they can seek to correct it. Rather than taking those steps, we say that the Crown in fact appears to align with those voices. There's also practical prejudice to claimants that we've set out at our paragraph 177 of our openings, which flows with not having customary marine title recognised. And that includes denial of ownership over the minerals and resources and potentially being able to use those for commercial purposes, or just ensure that you have the ability to exercise kaitiakitanga over them to stop councils or individuals from taking those resources. Denial of the prima facie ownership of those newly found taonga tūturu. Denial of the ability to exercise applicants' kaitiakitanga through use of the various parts of bundle of rights, including the resource management permission right. Denial of the ability to lodge a planning document and have it taken into account. And of course, the wahitapu protection rights are denied because without customary title, despite this tribunal's recommendation that wahitapu and customary marine title should be decoupled, without customary title, applicants cannot seek to have their wahitapu protected under this Act. So we say that an Honourable Crown in these circumstances would apologise, it would abandon the proposed amendments, it would engage with all Māori to implement the 2023 recommendations of the Waitangi Tribunal, and then use the Marine and Coastal Area Act in that form as a stopgap measure while it continues the long conversation with Māori required to provide for a tiriti compliant regime. Now, I've set out in my opening submissions the evidence that's been filed on behalf of the claimants that I represent and the interested parties that I represent. And I'm happy to take you through that, or I'm, given the time, happy to have that taken as read, and we'll address that again in closing submissions.
Isa, thank you, Mr. Lyle. I think that's probably the better way to deal with it, but it's very helpful to have that in the opening, so thank you for that.
Right, well, unless Your Honour or the panel has any questions, those are my openings this morning.
Thank you, Mr. Lyle. We don't have questions for you at this stage, but I just want to acknowledge you for that very helpful opening submission. Ms. Dixon.
Tēnā koe, sir. I believe I've been pushed up the order reluctantly, but here we are. The submissions that I have, the opening that I have, Your Honour, is on behalf of the two claimants, Patu Harakeke and Ngāti Wai Trust Board. And so the focus really in my submissions is on where they're at in this whole process, where they're at, what the impact will be on them as applicants in live trials. So I support the opening submissions and the foundation, the whāraki that has been put down by Mr. Lyle, and also acknowledge the other submissions that will be made by other counsel on specific points of the proposed amendments.
Ms. Dixon, can you just assist with the document number for your opening, please?
Certainly, Your Honour. The document that I am referring to is 3.3.4.
Thank you.
So I too will be just speaking to most of the points in these submissions. As indicated, both parties that we represent are in trial as we speak. The Whangarei Harbour 1A trial took place from February through to May this year, and the Whangarei Outer Harbour Stage 1B hearing began last Monday. This is currently week 2. Today and tomorrow has been vacated. However, we are right in the midst of a MACA hearing. As it stands, the Whangarei Harbour 1A hearing is yet to be determined, but it has been closed. So that still brings it within the proposed amendment for retrospectivity, taking it back to the 25th of July. And these are significant amendments in my submission, which will render the evidence, the submissions, the time, the court resources void. And not because one party has caused a miscarriage of justice or there's been a significant error of law. There's been no substantive new evidence that is going to realign the entire case. It's merely because the Crown will not allow Māori to gain bundle of use rights. And that, Your Honour, I say is unjust. It is because of that retrospective effect that is being proposed that the urgency that this must be dealt with is heightened. And these are speaking to paragraphs 1 to 6 of my submissions. If I turn to the next section, which is at paragraph 7, we set out there the claimant's overall position, and it essentially aligns with the main submissions made by my friend Mr. Lyle. What is obviously distinctive with our two claimants is the evidence that they have brought talking of their inherent connection to the moana. And that is seen in both their names and in their kōrero tuku iho that has been presented before the High Court. At paragraph 11, we refer there to what the tribunal has already confirmed, that the Act in its current form has had a significant impact on how the takutai moana as a taonga is accessed, used, managed and protected, and by whom, does not sufficiently support Māori and their kaitiakitanga duties and rangatiratanga rights. It is in breach of the treaty principles of active protection, equity and equal treatment. And like my friend has already indicated, the Crown has failed to take steps to implement the recommendations of the Stage 2 report, and therefore further exacerbates the prejudice arising from the breaches already found. The proposed amendments will reinterpret the test for obtaining customary marine title, and the result is CMT awards will be out of reach of many Māori and will reverse judicial decisions on the claimants, on which the claimants intend to rely. So, Your Honour, we have a situation where not only is the Crown failing to meet its tiriti obligations generally, they fail to respond and meet the findings and recommendations that have only been made by this tribunal not even a year ago. And like Mr. Lyle has said, it takes us even further back from that. The breach is heightened in my submission. At paragraphs 16 to 28, we talk about the lack of consultation and the failures in reaching the principle of partnership. And we set out there that the tribunal found in your report that the Crown breached the treaty principle of partnership because they failed to adequately consult with Māori during the development of the Act. The principle of partnership requires both treaty partners to act reasonably, honourably and in good faith, and the Crown's duty is actively engaged with Māori on how it should recognise tino rangatiratanga. We say there at 19 that the tribunal has made it clear and it is essential that a full discussion take place with Māori where legislation may impinge on Māori rangatiratanga over taonga, and the Crown must engage with Māori and allow them to exercise tino rangatiratanga as part of the decision-making process. That simply has not taken place whatsoever with Patu Harakeke o Ngāti Wai. And I guess that leads to two fundamental kind of points in relation to consultation, that these two bodies that we represent are representative bodies of hapu, and that's where it starts for them. That consultation must start with the hapu who hold and use the takutai moana. We do support the submission of Mr. Lyle in relation to Māori generally must be consulted on a significant proposal as this. However, note the submission by my friend Ms. Sykes that Māori are not a homogenous group, and therefore that is where we land in terms of the overriding obligation the Crown must have to consult with hapu. Secondly, in relation to consultation, the fact that these parties and others are in live trials must heighten, again, the obligation to consult. The Crown sat through 12 weeks, and from all accounts of the documents, sat on 12 weeks knowing that this was in train, that this was being discussed, and nothing was put before the court to raise these issues with the applicants in the whangarei hearings, that is. This breach, we say, is compounded by the fact that the Crown had meetings with seafood industry representatives about the proposed amendments on the 21st of May. But still, no consultation with the hapu, the applicants involved. I'm now at paragraphs 29 in relation to the breach of the principle of active protection. And I think, Your Honour, for the most part, that has been dealt with by my friend Mr. Lyle, so I don't want to belabour those points there. And so perhaps if I move to paragraphs 35 onwards, where we speak to the issue of retrospectivity. This section really speaks to the time and the effort, the mātauranga, the kōrero, the court resources that have been utilised to date. For both of the applicants or claimants that we represent today, many years of time and resourcing has gone into the preparation of their case. And I take this opportunity to mihi to the loss of the patuharaki ki rangatira a Praere Pirihi, who passed just before the Stage 1B hearing was to start. These are real things that the hapu are facing, the loss of significant knowledge and mātauranga, whilst the Crown meddles and changes things as it pleases, essentially. And so, in relation to the proposed amendments being retrospective, of course our fundamental recommendation and finding sought is that this whole nightmare be put to bed and be thrown away. That's in the first instance. The proposed amendments just simply do not happen. At the very least, our claimants say that they cannot have a situation where the law, as it stands, at the time that they are being heard, at the time at which they are being determined, must mean the law that applies at that particular time. Your Honour, moving to paragraphs 39, under the heading Protection of Rohe Moana. Both claimants are active within the resource management area within their rohe, and they have to be because they have large commercial interests sitting on their shoreline. They have channel infrastructure with the refining company. They have Northport. They have Golden Bay Cement. They have marinas, amongst many other things that are impacting their whenua, their takutai moana. And so for them, the protection of the rohe moana, time is of the essence, Your Honour, in terms of these applications being able to be heard and determined in a timely way. And reference was made earlier about the takutai, about MACA Act providing a bundle of use rights. And that is all that the applicants do receive under this legislation. But there is a fundamental protection mechanism that is available to the applicants, and that is under Section 58, and the ability to halt any further degradation of the rohe moana through the resource management process. We say, sir, that the claimants are owed the fruits of their litigation, they're owed certainty of law, and the active protection of their taonga by the Crown. The legislative changes proposed undermine these obligations and not only negate the Crown's duty to protect Māori interests, but expose Māori interests to the threat of further third-party interference, and that's at paragraph 42. We've set out there the redress for the Crown's breaches. One point that we hadn't included in here, but I do note is in submissions of others, that's the recommendation that this process, the Crown wait for the Supreme Court hearing and determination. As you may be aware, neither of our claimants have participated in that process, but we truly endorse and support that recommendation of our friends. We filed 3 sets of evidence on behalf of the Ngāti Wai Trust Board, 2 of which relate to resourcing matters, but we do have Mr. Arapita Kiripiti Edwards here with us at the request of the Crown, ready for questioning, sir. We have also filed evidence on behalf of Ms. Julianne Chedham, and her evidence really speaks to the time and resourcing and the real impact that this proposal will have on Patu Harakeke as well. So those, sir, are my specific openings. I do intend to address other matters in closing, sir, unless there's questions.
Thank you, Ms. Dixon. We don't have questions for you, but thank you for your opening. Ms. Black.
Thank you, sir. Mr. Lyle comprehensively covered the points that we had intended to raise in opening, so I've just been writing up some notes since he's been speaking. So there's really 3 points that I want to address the panel on. The first being consultation, the second being process, and the third being rule of law. I'm just going to make some brief points on those. Starting, our document is 3.3.8. And if I can take your honour to paragraph 8.2. So we've set out a quote there from the NAFA report, but looking at it again this morning, I'm not sure that it's completely opposite. So the quote says that the Crown obligation to actively protect Māori treaty rights cannot be fulfilled in the absence of a full appreciation of the nature of the taonga, including its spiritual and cultural dimensions. This can only be gained from those having rangatiratanga over the taonga. On reflection, sir, after 20 years of foreshore and seabed debate and discussion, I think the Crown does have an appreciation. I think it just doesn't care. The other point I wanted to make starts at paragraph 8.5. Which is the matter of the Crown continuing to consult down rather than across. So this is not specific to this issue, but it is very apparent in this issue. The Crown is behaving as though the fiduciary relationship is similar to that of a doctor and patient, where one party has a lot of knowledge, skill and power, and the other party is something of a supplicant. We say that's not appropriate. We say that at 8.8 we use the example of 2 responsible ministers leading a matter with one minister's team running the admin. But that doesn't give that minister a controlling interest just means that they're responsible for providing the administration. Another analogy might be a marriage. If you have some trees at the end of your boundary and they're providing shade instead of sun, and you want to cut them down, and your wife says no, well, the trees don't come down until you've agreed a path forward.
Yes, I certainly don't have any tino rangatiratanga on that front.
Correct. The lands case notes that consulting downwards is particularly problematic when property rights are at stake. On to process. Mesdames Sykes and Cole consider that the answer to the Statement of Issues question number 5 is the process the Crown followed in development and implementation of the proposed amendments inconsistent with the principles of the tiriti. They consider that they can be answered in the affirmative based on the absence of information provided, and we agree with that. But we also say at 9.3 that this process is not capable of producing a treaty-compliant outcome because it's in service to an agreement prioritising a coalition to govern over the property rights and interests of Māori, whom the government is supposed to actively protect. This, in our view, fails to meet the standards of the lands test. Now, I note that we didn't cite the lands case directly in our openings, and I'll rectify that in closing, sir. And the final point, rule of law, we note at paragraph 10.1 that the National and New Zealand First Coalition Agreement explicitly pulls in the constitutional requirements of the Cabinet Manual. And in the paragraphs following 10.1, we say that through that, the treaty and the Legislation Design and Advisory Committee guidelines are also explicitly brought in. And we provide a quote from Professor Geddes' evidence, where he says at the end of that the guidelines provide that legislation should not deprive individuals of their right to benefit from judgments obtained in proceedings brought under earlier law or to continue proceedings asserting rights and duties under that law. So we say that in this matter, the coalition government is not even meeting its own explicitly agreed standards. And those are the points I wanted to make, sir. If the panel has questions.
We don't have questions for you, but thank you, Ms. Black.
Thank you, sir.
Mr. Hockley.
Tēnā koe te kaiwhakaua mihi ana ki ngā rangatiro o te tepu hoki. The document, sir, 3.3.1, which I'm quite happy to leave taken as read. The appendix I attached is 3.3.1a, and I will I'll be much obliged if our registrar could bring that up at some stage, not just yet. Māku e whakakanohi ana ngā rōpū e rua, te whakapiko, te hapu, me ngā uri o peta tinua ki whananaki, me te whānau o riwha rawa ko Rewati, he uri o Ngāti Wai hapu ki whangaruru, me ngā iwi o Ngāti Kuta Patukeha ki te rāwhiti. Ki tēnei wā, kaore no i tīmata ki te whakamahi i roto i te kōti matua, engari i tātari ana ki te mahi tērau. Tuatahi, re te tonu ki te mihi ki ngā mate i te ata nei. Koe ana te mihi ki te whānau whānui o te parawhau, me ngā hapu o te raki. Kua mate a te tito, a tērā wiki, i tērā wiki. Moe mai rā. Ki te temata o te, ki te koti matua, o whangarei te ringa parawa a te tō. Matua te ihi I tīmata te tuatahi o te taumata ki te whakatauana te kōrero. Ki tōku whakaaro tēnei te utu nui ki te tīmata. Tēnei te maumau tangata o te turi. Ki te no te wā o nehe rā, e haere tonu ngā hapu, ngā iwi, ngā whānau ki te mahi o te tiaki o te rohe moana, I mahi tonu tērā. Engari I roto I tēnei wā, kei te hiahia rātou, ki te haere ki te kōti mātua, ki te kawana, ki te tono, ki te mau, ki ētahi pepa, ki te whakaitera. Te nunui o te mahi, te maumau o te tangata, te maumau o te wā, te putia, ine ngā hara o te karauna. Ki tēnei wā, e pānei ki te kōrero o tōku hoa, Ms Dixon, I tīmata anō te kōti matua ki te ākau o whāngarei. Aha ko tērā, ngā rōpū katoa I roto I te kōti ki te marama, ki te marama te koretaki o te mahi. Ngā te moimoi ao te kawana ki te whakekore te otinga o te koti. Aha ko tērā. Aha ko tērā. E pāna ki te ngākau o ngā hapu, ngā iwi, ngā whānau I mahi tonu. Aha ko te koretaki o te mahi, kei te marama tērā. Tahi o te mahi o te kawana, te mahi o te roia o te kawana, I whakatauana te manatu roia, he pānui, te whakahuri o te ture. I roto I te litigation practice, chilling effect. He mea anō, I te puta mai o ngā rōpū o te kamupene, te landowners coalitions, ira momo mea. E tono ki te koti, me whakamutu tēnei. He kore taketanga. Te rerekētanga o tērā mahi, te mahi o te kawana ki te tautoko, ki te whakatauana he aratika, tērā te tinohara kei mua I a koutou I tēnei rā. E whanga miniti ki te break cert. Taia tōku registrar, can you bring up please page 5? On the appendix 3.3.1a. Tēnei etahi mihi ki tōku hoa roia, matua Bryce, I mahi tēnei. Ki te whakamarama, ki te kaiwhakawā, tēnei te ara ki te whaiana, ki te whakaputa mai, ngā mea katoa ki ngā hapu, ki ngā iwi. Tēnei te hinaki o te ture. O rite ki ira kōrero, he tika ia. He hara I roto I tēnei, ki tēnei wā. Mua te whakahau o te ture, o te kawana. Te tīmata o tērā I te rea o te hinaki. No te tīmata, te ture, i mikirapu ana ngā tikanga, ngā mahi o te ahi kā, te rāhui, te wahi tapu, ki te motunga, ētahi mea, ki te whakakanohi ngā tikanga o ngā hapu me te whānau. I roto i tēnei wāti, tēnei toku kōrero ki a koutou, i runga i nei kaupapa. Etahi o ngā whakataumutunga i pirangi te whakapiko, rewharawa ko Riwati whānau. Te tīmata o ngā hara i te mahi o te kāwana i roto i ngā minita noiho. Kaore o haere ki ngā hapu, ki ngā whānau, ki ngā iwi. Tuarua, te he o ngā pānui, ki te whakakoretake, te mahi o ngā hapu me ngā iwi. Tua toru, i ngā kupu o te kōrero o te kawana. He mea, tino hohunu tēnei. Nā te kōrero o te kawana i haere ki ngā huewha. Ki ngā marae, ki ngā hapu, ki ngā iwi, ki ngā nūpepa. Me te mahi i haere e tahi whakamāramatanga he. Te raru i hara i te turi. Te mahi o te hapu me ngā iwi, me ngā whānau, ki te haere, ki etahi wā, ki te mau, ki tētahi mea, ki te whakanui o rātou tikanga. He mea tika. Rua takau, ngā tau no te timato i nei. Aho ko tērā, tino kaha te ngākau o ngā ropu ki te mahi tonu. I whakatau ana te rāhui, i mau tonu ki te ahi kā, i haere ki te kōti, i hui mai, i te kawana, me te minita. Ko tērā, kaore i whakatau ana te minita e tahi title ki e tahi ropu. Engari, e te kaiwhakawā. Era ngā kōrero no tōku ropu e rua, mena he pātai mai. Engari, kōti.
Thank you, Mr. Hockley. That brings us to the time for the morning adjournment. So we will adjourn for the morning break. I do see that, according to the timetable, we only have a further 15 minutes for opening submissions, and there are still a number of counsel who have not yet presented. So I would encourage counsel to confer to work out how best to address that over the break.
Sir, I did wonder, off to a poor start, but whether we shorten the break to 15 minutes this morning so that we can have a little more time, and we'll work with claimant counsel to make sure we fit within that. That would create a half hour to land the opening submissions.
We'll perhaps shorten it to 20 minutes, Mr. Lyle. I know we do have a little bit of a hike to get our panel upstairs and down again. So we'll shorten the break for 20 minutes and we'll reconvene at 10:50.
As Your Honour pleases. minutes that we have, perhaps by 10 minutes or so. But looking at the timetable and discussions with the learned friend for the Crown, we think we'll make up that time and cross-examination time of witnesses not being required. So with Your Honour's leave, we'll proceed in that way and continue with opening submissions.
Thank you, Mr. Lau. Mr. Benyon.
Yes, sir. The document you're looking at is 3.3.15, and I'll keep myself to 5-ish minutes. 5-ish. So I think I'll just make 6 points, speaking to the document. The first is not in there, but I just want to convey the dismay, the exhaustion, the confusion, the chaos which this policy announcement, this sort of pseudo-policy announcement is causing. I mean, I'm involved in the whakatohia proceedings for Ngāti Patamoana, involved in whāngarei for Ngāti Pukenga, and involved in for Mua Upoko, my clients here today, in the Kapiti Coast hearing, and we just had 6 weeks of evidence there. So just so many years getting ready for that difficult process anyway before the High Court, going through that, such intense preparation, and now just scattered to the winds by this proposal. So that's the first point. The second point is I have laid out in my submissions from paragraph 2 in detail that meeting of the Ministers of Oceans and Fisheries and the Minister of Treaty Negotiations on the 21st of May. And I won't have time to go through this, but I invite you to carefully read each line. And I struggle to remember in any of the Waitangi Tribunal's historical reports, I struggle to remember a meeting that is well, it equals many 19th century meetings where Crown officials would go to one group, to iwi, and say, we've got your interests at heart, we will deal with you in good faith. And then the very next moment, in this case just before, the day before, frank exchange with a private interest group saying, your interests are primary to us, we commit, there's a word commitment in there, I commit to the Section 58 changes, says the Minister, to the seafood industry. The Minister of Oceans and Fisheries doesn't realise, doesn't even know, as a man who signed the coalition agreement, that the regulatory rights that will come under the Takutai Moana Act include the ability to veto resource consents. And he says, oh my goodness, I did not know that, that will have to stop. And the Minister of Treaty Negotiation says immediately, we're going to make it so that only a small percentage of the coastline is affected. I mean, that is, on any assessment, outrageous comment and behaviour. Third is to say that there is a broader constitutional question the Tribunal might like to contemplate, which is the comment from the Legislative Design Committee, where they say that the coalition agreement essentially repeats a piece of constitutional illiteracy. It says we're going to restore Parliament's intent, and LDAC tells them, in June, tells government, that doesn't make any sense. You can't do that. The law is what the court has said. So you're not restoring Parliament's intent, you're just making new amended law. How on earth do we manage our constitution if we have coalition agreements which have pieces of constitutional illiteracy in them that then become policy that then officials are being asked to comment on? That seems to me a point for the Tribunal to consider, and how we approach that. Are political parties and our governments making agreements, how do we brief them in the way we do on financial matters? How do we brief them on the constitutional settings, the depth of them and the importance of them around treaty issues? That seems to be a large question. The fourth point is around fast track. We've asked the Crown whether there's been commentary about the link between the Fast Track Act or bill and this proposal, remembering that under the Fast Track Bill, if most of the coast is under CMT orders, you cannot bring projects into the Fast Track process. You have to ask those iwi. That's what the Fast Track Bill provides. So by cutting down the
CMT space, the ministers are allowing the fast-track bill to actually operate, because otherwise it couldn't operate on large parts of the coast. We think that's an important linkage, and we're wondering where that is. 2 more points. Fifth point, we object to what we think is about to happen here, which is we think the Crown has lined up the witnesses for examination to ask them questions about how they feel about the policy and to hear their concerns. We think it's objectionable that there is no detailed policy, there is only some outrageous statements about retrospectivity and how and when it might apply, and that this process, this very process, might be being used to allow the government to say, goodness, we heard from so many iwi on this issue. We object to that approach. And then finally, just a last point we make in our submissions, which is that we are concerned, and this is a point perhaps for the Tribunal to think about for its report, about how Crown officials are being used in this process. Because if the government is having meetings, which I'll call them meetings off the books, if you like, but they are on the books with the seafood industry, where they're having free and frank exchanges and saying, we will cut down CMT because you've got concerns about seafood matters, but that is not coming into the advice, and officials are not being asked to comment on that matter. Instead, they're being sent on a wild goose chase to find out what Parliament's original intent was. Then those officials are becoming involved in a scheme, if you like, of misleading the public unwittingly, and we think that's a misuse of those officials and their neutrality. So those are the points for opening. Thank you, sir.
Thank you, Mr. Benyon. Mr. Sharp.
Your Honour, my opening submission is at 3.3.13, and I won't read or address hardly any of it. Just to say that where my submission's a little different from others is that I have a focus on what the actual amendments that are suggested to the MACA Act are, and what possible basis that they have. In particular, the proposals propose quite strict property or literal-based property law principles, which there had been previous discussions would probably an effective means that hardly any, if any, CMTs will be awarded. The ostensible basis for these amendments is very difficult to ascertain. There's no real discussion about it. It comes after there's ministerial advice that it's not, that sort of approach is not justified by the attention of Parliament, but just seems to be some amendments which the Minister thought appropriate to get results which he thought that the legislation should deliver. They are, seems ostensibly based on Canadian law principles, but in my submissions, they're not Canadian law principles relating to the same tests of substantial, of exclusive use and occupation and substantial interruption are quite expressly said to be not property law based principles, but rather sui generis to customary title. And you see, I've filed an affidavit from an expert on Canadian law, Mr. Roger Townsend, who concludes, amongst other things, that the Court of Appeal test in Edwards for CMTs is already stricter than Canadian law is at present. Now, given that it appears that these tests have really no rational, genuine basis, I just raise the issue of the constitutionality of these principles, and of particularly pertinence is the Matapono report this tribunal has delivered, where Crown actions to reduce Māori rights, which are not based on good faith, really get to the edge of whether Parliament is able or capable of taking that action, those actions. And in the Ngā Matapono report, in fact, this legislation was cited as part of a suite of cynical Crown actions which are intended to which intended to use parliamentary sovereignty to reduce Māori rights. So in the end, it's encouraged the tribunal to look boldly at the constitutionality of these issues, much the same as the Ngā Motopona report did. Those are my submissions.
Thank you, Mr. Sharp. Ms. Thornton.
Sir, I'll be brief. I don't want to recapitulate anything anybody else has said, so I'm going to focus on the issue of the origin and endurance of customary rights. As Your Honour and the panel will know, this whole controversy is about customary rights, and of course, customary rights were recognized as early as 1515 and are accepted as predating any of the rights of the colonial powers in any of countries that were settled. And the fact that, that recognition is sort of underpins the foundation of this country on the basis of a treaty. So until Māori right, and the treaty, of course, recognized Māori rights to their land and waters and also to their self-government. So all of this that follows on afterwards is borders on a breach of the treaty and a breach of the international law of Indigenous peoples. And the fact that the New Zealand Parliament now considers itself able to just manipulate this situation so that they can present that they have a law that protects Indigenous rights, which in fact it is meant to take them away, is rather well, as Mr. Bennion said, it's misleading and it's disingenuous in the extreme. I don't want to go over anything else. I'll cover that off in my closings, but because I know we're pressed for time. But those are the issues I really wanted to raise. Thank you, sir.
Thank you, Ms. Thornton. Ms. Hiruani.
Tēnā koe te kaiwhakawā. Mihi ana kia koutou, e mihi ana hoki ki ngā tāpaitanga o Akuhoa me te tautoko i e rā tāpaitanga a ngā mātou kiritaki. Ko taku tāpaitanga whakataki ko tana nama ko te toru ira tahi ono. E mohi ana he poto te wākia, engari e hihi ana ki te mihi ki ngā āhuatanga ko tai mai nei ngā kaikireme ki mua i a koutou. Kua mate rātou ki te tai mai anō i tēnei wiki, ki te kōrero mo tā rātou tino rangatiratanga ki te rohe moana, taku tai moana, a rātou taonga, a rātou tikanga anō hoki, no reire mihi ana ki te rā āhuatanga. Ka ki ake a hau i konei a mātou kiritaki ngā kaikireme, ngā tirehia, ngā ti tamai nupo, ngā karanga hapu o ngai te hapu, e tino whakahea ana i ngā mahi, ngā tukanga me ngā panonitanga ki tēnei ture o te taku tai moana. Koira pū te tūranga o ngā kaikireme i tēnei wā. Kei taku kōwai toru tekau mā wariwe te kaiwhakawā e kōrero ana, e whakarāpopoto ana i te tūranga mō enei kaikireme. Engari ko te eta pia o awa kōrero e kōrero ana mō tā rātou tino rangatiratanga ki te rohe moana. Engari e tino whakahua ana i a rātou tikanga me te whakaro, me te rongo ki roto i a rātou e tino takahi ana e nei panonitanga i ngā tikanga o ngā hapu o ngā kaikireme i te tukanga e whaia e te krauna kua takahia ki tia ngā tikanga. No reira, koera te tahi o ngā tino take e hiahia ana rātou ki te whakaputaki mua i a koutou. Ki te kōrero a hau mō kei hea ke ngā kaikireme kai kreme ki roto i ngā tukanga o te MACA Act. Ngai te hapu, kua tai atu ki te kōti teitei, kua rongo te kōti teitei i a rātou taunakitanga, kua mutu tērā wāhanga ki a rātou. Ko rātou i tēnei wā he tatare noa ki te kōti, kia whakatau i ngā tono. Nō reira, ki te whakaaro mātou ki tēnei mea te retrospectivity e te kai whakawā e he pānga nui, he whakahaweatanga nui ki runga i a rātou. Nō reira, koira rātou e tai mai nei ki te whakahe. Ngāti tamaunu pō, i te wā i taitai rātou ki a koe te tau 2021. Kaore rātou i tuku tono ki mua ki raro i te ture rā. Engari, nā wai ka mahi tahi ki etahi o ngā rātou whanau ngā hapu o Whaingaroa. Ka tuku rātou i te tahi tono whakatika nā kua manata rātou tūnga ki mua i te kōti teitei hei kai tono motuhake a Ngāti Tamainu pō. Ko te kōrero te kai whakawā, ka tūpea he nohoanga te tau 2026. Engari, e ai ki a rātou ka tino raru te era whakaritenga. Ka mati rātou ki te tatari anō kia tai ki mua i te kōti teitei. Ngāti rehia, he rereke anō tō rātou tūranga, he kai tono tō tika ki te krauna. Engari, kua ki te koe i roto i ngā kōrero taunaki, kāre anō kia whanaki haere tērā tukanga mō Ngāti rehia. Nō reira, ki te ana i ngā rereketanga ki wānga i a rātou. Engari, ko te mea nui, he whaipanga, he whakahaueatanga, ka pā ki a rātou katoa. Mātā mua ko te takahi a rātou tikanga, te tino nawe, te tino raru nui e ai ki ngā kaikirime ka mutu i puta i a rātou e tahi kōrero mō ngā pūkōrero, mō ngā mātanga, mō ngā pūkenga, i tautoko i a rātou tono ki raro i tēnei ture. Ētahi o rātou, kua kite i te taunaki mō ngai te hapu, kua mate noa, kua hinga atu rā no reira, e whakaro ana me pēhea rātou e tikina atu i era mātauranga anō ki te mate rātou, ki te tai anō, ki te kōti teitei, ki raro i enei ture tikanga panonitanga a te krauna. He māharahara nui tērā ki a rātou o tirā ki ngā kaikirime katoa i te kaiwhakawā. E tautoko ana i ngā whakahaweatanga kua kōrerohia ki tia e au. Me ngā rongoa e kamihia nei e ngā kaikirime katoa ko a mātou kiritaki e tautoko ana kia mutu. Ngā panonitanga a te kāwanatanga, ka kōrero tōtika ki te Māori, ngā hapu, mō kia whai te tahi māramatanga, kia whai te tahi whakaitanga mō tēnei kaupapa e tika ana kia pērā te krauna no reira ko te tumanako e whakarongo ana ngā mineta, ngā āpiha o te krauna i tēnei wiki i te kaiwhakawā. Ka mutu i reira ku tā paitanga me he mea he pātai a koutou.
Tēnā koe, Ms. Hiruni, kaore a mātou pātai, engari tēnei te mihi ki a koe i tō tāpaitanga.
Tēnā koe.
Mr. Naden.
Tēnā koe. Mr. Naden is having some IT issues, so I'm not sure if he is in the waiting room. But perhaps if we could...
Mr. Naden.
Yes, Your Honour. Here now, sir, with some connection problems earlier, but perhaps we're underway. Your Honour, there are some submissions on the lack of consultation. This topic's been addressed previously. Ours is just to say that there's a significant impact apparent on the relationship of the claimants with their taonga, and it's in those circumstances where it's well established, sir, will be aware that a high level of consultation is required, and that has not occurred. So there is this treaty breach, and members of the panel of the tribunal should find accordingly that there are due process issues as well. Interestingly, former Prime Minister and constitutional law academic Sir Geoffrey Palmer, the New Zealand Law Society and others have expressed deep concern with how this government legislates. Turning to inept policy rationale. All legislative change requires clear policy objective and rationale. Why change the law if there's no good reason to change it? We say there is no good, well, no valid or even apparent policy rationale here for change, because on the one hand we have Mr. Goldsmith talking about a high threshold test so that just small areas can be granted, and yet Chatawhiti officials, after analysing, I quote, the body of evidence, unquote, indicated a less restrictive test, a less restrictive intent test. So the lack of clarity around the official meaning of Parliament's original intent negates existence of a robust policy rationale, and so parliamentary processes, laws that have been said, or law making, not being followed in this respect. In addition, found so-called policy rationale is being used to obfuscate the government's true intent, proposed amendments, which is to severely reduce the number and extent of CMT awards in the Takutamu Moana in favour of advancing economic development in the interests of industry stakeholders. That this is on this record. Turn now to issues with legislation, proposed legislation in regard to the declaratory statement in comity. Submissions have been made in this respect, and so council will be short, but other than to say that there's it's important with declaratory statements that restraint is the approach that Parliament should take, because if such statements are made, there's the undermining of mana of the senior court. We're saying that that is the outcome of what's been proposed with the proposed amendments. Chatawhiti officials advise that there must be any declaratory statement, there must be only enacted in cases that manifestly warrant such warrant. This is a very high standard. The standard is set so high because of the importance of maintaining public confidence. Say the standard has not been met because of the confusion with regards to meaning of Parliament's intent. So the policy rationale cannot be used to manifestly warrant. So again, rules for making not being adhered to. Submissions have been made on the Parliamentary Privileges Act. Agreeing Mr. Lyle, those submissions are supported. The circumstances for the PPA, Parliamentary Privileges Act, are not here. The Crown in this instance. Here with the PPA, it was a Supreme Court decision as opposed to a High Court of Appeal decision that was overturned. Also, the PPA specifically excluded a law change to existing legal proceedings and retrospective. So this is government's other rationale for the respective amendments, and it cannot stand. In terms of retrospectivity, submissions in that regard have been made, but other than to say that strong reasons are required for retrospective legislation in order to avoid infringing the law, policy rationale is not available to the government to justify retrospectivity. Crown's attempt to justify retrospectivity is also at issue. It overrides the court's constitutional role as independent dealers of the law, runs contrary to the principles of permitting, separation of powers doctrine. Just lastly, side wind extinguishment, paragraphs 36 to 44. In the Attorney General Ngāti Apa case, the Court of Appeal stated that any attempt to extinguish customary rights must be made clear and plain legislation. This is required because native property rights are not to be extinguished by side wind. And in conclusion on side wind extinguishment, say at paragraph 44, proposed amendments are designed to make the CNT test stricter, drastically reducing the coastline subject to CNT recognition from 100% to 5%. We document discovery in support of that 100% to 5% submission by imposing a literal interpretation for exclusivity and substantial interruption. Proposed definitions will effectively distinguish Māori customary rights by a side wind by setting an impractical threshold for CNT recognition. There are some submissions on compensation consequence as a result of side wind extinguishment. But, Your Honour, members of the panel, unless there are questions, I'll end it there.
Tapu. Thank you, Mr. Naden. We don't have any questions for you, but thank you for your opening submission. Mr. Hira, Ms. Cole.
O tēnā koe te kaiwhakawā, nā mema o te Tiraipūnara. I'm appearing, as was indicated earlier on instructions from Ms. Sykes. So these submissions come from us as a rupu. And we're not intending to canvass our quite detailed opening submissions that we've filed, but rather speak generally to the matters before the tribunal. Our oral submissions are very general in nature, not specific to our clients' claims or before the Waitangi Tribunal or applications before the court. I'm going to assume that our written submissions have been read in advance, or certainly will be before putting the heads down to write the report. Members of the tribunal, we are concerned with what we're going to call the astonishing short-sightedness of the Crown in doing what it is proposing to do in relation to the MACA regime. Our clients ask rhetorically in our opening submissions, has the Crown learnt nothing from the past? Now, our clients very much looking forward to the representatives of the Crown appearing at this inquiry, standing up and doing the honourable thing. We encourage the Crown to do what is right. Act honourably, respect te tiriti, respect your treaty partner, get up and acknowledge that what the Crown has done here and is doing here is not right. It is not tika. It is in breach of te tiriti in so many ways. Acknowledge that Māori will be prejudiced by these actions. Do as the claimants across this whare and across the motu are asking. Stop this now. Let the Supreme Court hear the Edwards appeal, adopt the recommendations of the Y2660 tribunal report and any recommendations that come from this inquiry. Now, of course, we all know already that it is highly unlikely that the Crown is going to do any of those things. Instead, we will all passionately engage in this urgent inquiry. The Crown will sit there and they will look like they're engaging in it fully. The members of the tribunal and your kaimahi will go away. You will read everything. You will listen to what's been presented. excuse me. You will present or produce a report on what has happened and what is going to happen. You will find multiple breaches of te tiriti by the Crown, and you will make sensible and meaningful and helpful recommendations. That is your role. That is set out in the Treaty of Waitangi Act of 1975, an act that the Crown created. And once again, the Crown will ignore your recommendations. We all know that's going to happen. Just like they've done with the Y2660 reports. Like the Crown has done more often than not with any of the other reports produced by this tribunal in kaupapa and urgent inquiries. I have heard reports from the Waitangi Tribunal being used as doorstops in ministerial offices. They don't even get opened. The Crown will maintain that this inquiry is premature, as none of us have even yet seen the details of what they're proposing. And we trust that the Tribunal will see the irony of that submission. The Crown is determined to make amendments to legislation that governs how Māori can obtain recognition of their customary rights and interests in the Takutai Moana, but they haven't deemed it necessary to include their treaty partner in the process of considering this. How many breaches of te tiriti, or how many principles of te tiriti does that breach just in itself? We all are aware that the coalition agreement that started all of this has a provision in it that this current coalition government intends to take steps to put restraints on this tribunal, on the Waitangi Tribunal, by, quote, focusing the scope, purpose and nature of tribunal inquiries. Now, none of us know what that's going to mean either, or when it's going to happen. But for now, the tribunal is the only avenue our clients have to air their concerns about these proposed MACA Act changes. Some very short matters now. The tribunal is not being asked, despite it being addressed in a number of the opening submissions that have been filed by Claimant Council, to address the rights or wrongs of the Court of Appeal's majority decision in Re Edwards. That is the job of the Supreme Court. This tribunal's task, of course, is to assess the evidence and submissions which go to the issues that are contained in the tribunal's statement of issues. We say that the tribunal is going to have some difficulty in answering all of the questions raised in the statement of issues, because we say the Crown, acting dishonourably, has not been willing to give the tribunal all of the information that it has in its possession that is relevant to the matters before the tribunal. By not being fully transparent, the Crown can explain away any findings and recommendations that you may make by pointing to the fact that you don't have all of the information. Minister Jones can explain away any comments he has made about communist judges and people reacting negatively to these changes as being hysterical hobbits, which was something he did that I saw yesterday afternoon in relation to the fast-track consenting bill. He'll describe that as political rhetoric. And ironically, in the opening submissions filed for the Crown, not once, but twice, Counsel for the Crown make reference to their client's voluntary provision of documents, like the Crown should for some reason be applauded for giving us what they gave us. We submit that the tribunal can and should draw negative inferences against the Crown's conduct from the lack of information voluntarily provided to this Permanent Commission of Inquiry. We submit that the key issue for Cabinet in, quote, making decisions on the proposed amendments to the MACA Act, given the rationale for the amendments is to restore Parliament's original intent, must surely be, the key issue must surely be, what was Parliament's original intent? And we submit that the paucity of disclosure concerning that key issue is striking, and the tribunal should draw negative inferences against the Crown. The matter of the Parliament's original intent has already been addressed sufficiently by my friends Mr Lyle and Mr Benyon, and we also wish to support the comments and observations made by the Legislative Design Advisory Committee. The Legislative Design and Advisory Committee, the Crown's not even going to willing to listen to them. Concerning the analogy that we have drawn in our opening submissions between the Marine and Coastal Area Act regime and historical treaty settlements, we sought to draw attention to the fact that acknowledgements of and apologies for past Crown misdeeds is now commonplace in Aotearoa. The acknowledgements that we see in most, if not all, treaty settlements, historical treaty settlement deeds concerning the native land laws of the past could be used as a template for what we are seeing right now. They are acknowledgements and apologies that some future government may well make about what is happening right now. The acknowledgements record the great prejudice suffered by Māori. We all say that that is exactly what is happening here, or is going to happen here. The acknowledgements note that the laws made whenua, here Takatai Moana, more susceptible to alienation. They acknowledge that the laws the old native title laws eroded the traditional social structures, mana and rangatiratanga of settling groups. And finally, they recognise that Māori had, quote, no choice but to participate in the system which was the only means to obtain legally recognisable land title, which was protected from claims by others. This is history repeating itself. In our opening submissions, we drew attention to the about turn the Crown has made in its position that it had adopted in the Y260 inquiry, 4 years ago. We point in our opening submissions to the evidence from Ms Smith, who was a Crown witness in that inquiry, and to legal submissions. And we are looking forward to hearing the current counsel for the Crown to explain that about turn to the tribunal. Finally, we want to draw attention to the Crown's failure to take any steps to date to correct the mis- and disinformation out there in the wider public as to the meaning and effect of recognition orders or agreements under the Marine and Coastal Area Act regime. My learned instructor, Ms Sykes, gave a speech 14 years ago, which may well have been written yesterday, and I want to repeat some part of it. One of the other features of the Marine and Coastal Area Act, as an insert Marine and Coastal Area Act proposal, one of the features of the Act proposal is public access to the foreshore and seabed. These are key features played out in the media. The government deliberately misinformed the masses. The Māori claims to the foreshore would deny access to Kiwi beaches. This was in spite of Māori efforts to convince the public that this has never been the experience of our nation and was never the intention of Hapu and Iwi. While the proposal ensures public access to the foreshore and seabed held in the, quote, public domain, this is no requirement of private owners who own approximately 80% of the remaining shorelines. Clearly, this is a further injustice which only highlights the discriminatory views of our treaty partner, the Crown, and how far we really haven't come as a nation. If you have any questions.
We don't have any questions, but thank you, Ms Cole, for your opening submission. Ms Irwin Easthope.
Tēnā nō koutou e te pai. If I can just check that you have document 3.39 in front of you, which are the opening submissions for Te Runanga o Ngāti Awa. I will also take you to an A3 map, which I understand has been handed up this morning, which is from Mr. Ruben Araro's evidence. Just while you're laying your hands to those documents, I'd like to start by echoing the concerns that my friends have raised this morning, particularly the sentiments about these proposals in process and substance being unjust and unconstitutional. Now, that is certainly the thrust of the case for Te Runanga o Ngāti Awa. Given the ground that my friends have traversed this morning, I'm mindful of what you've already heard, so I only intend to make three discrete points. The first is the unfortunately unique position that Trona and Ngāti Awa find themselves in. A comment on the effect of the Crown's intended proposals on our constitutional arrangements, and to conclude, a note on intent and the relevant coalition agreement between the National Party and New Zealand First. So firstly, if I can just check It's always the dilemma when you bring up paper to a podium. This is the map I was referring to, entitled Trona Application and Overlapping Priority Applications. Great.
Yes, we do have that, thank you.
Thank you. Now, this map is in the evidence of Mr. Araroa, but is smaller. So, as you can see, due to the way in which the Act provides priority for applications that were filed under the Foreshore and Seabed Act, Trona and Ngāti Awa have effectively been forced to participate in a particular way. And the way in which they have had to participate is to first participate in approximately 18 weeks of High Court trial on their border. So the first, as you can see to the east, is the Edwards proceeding. That High Court trial was held for 10 weeks in 2020. The second is Reader. Now that's stage 2 Reader. That was the trial held in 2021 for 7 weeks, which my friend Ms. Hedawini referred to this morning in her openings. And so in terms of, if we start with Reader, the way in which the Crown's retrospective proposal was intended to work, as Ms. Hedawini signalled, is that that hearing that took place in 2021 needs to be reheard because we do not yet have a judgment. And just if we take Trona's applicant grouping alone, for Ngāti Awa, 4 of its witnesses that participated and presented at that hearing have since passed away. That's the first point. The second point is that that hearing, as Mr. Araroa disposes, was an incredibly difficult hearing for those that were involved in terms of the whanaungatanga relationships that were again put at strain in relation to the way in which groups are required to participate under the Act. And to suggest that actually another trial can simply take place, that yes, this is a retrospective application, that's all intentional, but we will just determine that that is what's going to happen and proceed with another trial, is frankly offensive and a complete waste of not only court resource, but a waste of the people's time that have participated in good faith to date. The third issue in relation to Trona's unique situation is that in relation to the Edwards proceeding, it is Trona's submission which is set out further in the opening written submissions that actually it is quite unclear as to what is going to happen with the Edwards proceeding. So in one of the earlier press releases of the Crown, the Edwards box said that there would be no impact. So as a result of these changes, no impact on the Edwards proceeding. Now, that lends us to agree with Mr. Lyle's submission that if that is the case, you would have to have a carve-out legislatively, potentially, to allow that proceeding to continue on a separate track so that it's under the previous iteration of the Act. However, it is unclear on the Crown's documents whether that is what will happen, and so another option or another possibility that we've highlighted is that actually the Supreme Court says we're going to send it back, as the Court of Appeal did, maybe not on the same basis, but then the High Court proceeds with those applications, of which there are a number, under the old regime or under the new regime. That's unclear. The final option that we've included in our written openings is that the Supreme Court might just uphold one of the decisions or uphold Justice Churchman's judgment in substance, so that would result in potentially CMT holding for particular groups and no further hearings being required. But, I mean, based on our client's specific interest in this matter, from our perspective, it is unsatisfactorily unclear that the Crown has essentially not clarified what the position will be following the Supreme Court's hearing of Edwards, which is still set down to take 2 weeks of the Supreme Court's time, and not to mention the applicant's time, in 2 weeks. And finally, on Trona's application, their application in substance in the green area, so the residual part of their application, which is in fact the majority of their application, is due to be heard in May 2025. The applicants there are collaborating and coordinating and have since sought extensions of time in light of the existing uncertainties, but have flagged to the court that it may be that an application for an adjournment at a later stage is required. It's simply not able to be made at this stage because we cannot and we do not know the extent of the Crown's proposals at this stage. So the second substantive point in opening is a comment on the effect of the proposed approach in the context of our constitutional arrangements. And I won't labour this point because there is an obvious alternative option here for the Crown, and that is to behave constitutionally and to allow the Supreme Court to hear the appeal. Now, the Crown is quite intently and deliberately cutting across that option. And finally, in relation to intent and the coalition agreements, and not wanting to labour this point because it has been made, we will just conclude with the point that we make at paragraph 27 of our opening submissions. And I would say that we don't make this point lightly. I don't think anyone is making any of the points that you have heard lightly this morning. But this is simply a case of political reverse engineering, where the Crown has an objective for political reasons driven by political commitments made before the election, sought out a policy problem that did not exist, that does not exist, such that the solution to such problem is a problem that does not exist. To take Her Honour Judge Fox and that tribunal's recent finding in the Ngā Mā Tāpono report. And perhaps to put it another, more simpler way, it's simply a farce. And so to conclude, we say on behalf of Ngāti Awa that this is a particularly egregious, unjust and unconstitutional situation. The Crown needs to hear these concerns. It has time to hear them and it has time to stop. So me waiho ngā kōrero Ngāti Awa ki kona, unless Your Honour or any of the members of the panel have any questions.
You made the observation that one alternative was for the Crown to allow, was the wording you used, the Supreme Court to hear the appeal. Are you suggesting that there has been some Crown attempted suggestion or action in relation to what the Supreme Court does?
Sorry, Mr Crosby, I think the point that you're picking up on there is that, of course, at this stage, the Supreme Court is hearing the appeal in November for 2 weeks. The point there is, though, that substantively what the Crown could do in this situation is allow the Supreme Court to hear the appeal and determine the matter that it says it is so concerned about, which is parliamentary intent. So the Crown has an appeal before the Supreme Court. One of the other options that, of course, LDAC and other officials have pointed the Minister to is that it simply allow the Supreme Court to determine the matter conclusively and then at that stage make a determination as to whether legislative amendment is required. Here you have a Court of Appeal decision where the highest court in the land of constitutional significance is not given the opportunity to determine what the law should be for the entirety or for the masses. Effectively, what seems to be the Crown's strategy at the moment is the Supreme Court hearing can proceed and it will have effect for a limited number of applicants, which in Trona's case again may mean that certain hapu of Ngāti Awa are subject to a less stringent test than other hapu of its own iwi.
Thank you, Mrs. Iwanisto. Tēnā koe.
Not entirely happy here, Sir Mr Benyon, that our witness has been bumped up the list, but I guess we're going for it. So I think it's Mrs Panaho's coming later. Yeah, okay. So, Sir, so we're moving to evidence? Yes.
Yes.
And you have, I'm just going to refer you to A51, A and A26, which are two briefs from Diane Rita Rump of the Māori Tribal Authority, and we'll just call her to the stand now. I should point out the first affidavit of A26 was filed with the initial application, so for urgency. Do you have those in front of you?
I do.
Okay. So, I'll just get these confirmed, and then Ms. Rump, you can speak to them. If that's all right. So you've got an affidavit of 9 July, affirmed on the 7th of August, and another one on another affidavit, second affidavit, 7 August. You confirm those for this tribunal?
Yes.
All right. And all right, if you introduce yourself and speak to your evidence, it'll be quick. And before you get to questions, I've just got one point of clarification I'll take you through with your evidence. But I understand you're just going to speak to it.
Kia ora.
Kia ora.
O tēnā koutou katoa, tēnā koe i te kai whakawā, Judge Armstrong, ngā mema i te rōpū o te tiriti o Waitangi, tēnā koutou, ngā mema o ngā rōpū roia, tēnā koutou. Ko kurahau te waka, ko tararua ngā pai maunga, ngā uri o Naitara, o mua upoko o te ika, ko Ngāti Hine te hapu, ko Kawiu te marae, ko Punahau te moana, ko Hoki o te awa, ko Dai Rump toka wingawa, he kura hoki oi toku mahi. Kia ora. My name is Dai Rump. I have the special privilege of being he kura hoki oi, or CEO of Māori Tribal Authority. In the Hora Whenua, our historic area goes from Rangitike to Tūraki Rai and Te Whanganui Atara. I have been in my role initially on some specific assignments and then sort of morphed as things do into a permanent role from 2016 onwards. I am here today on behalf of our people. We are deeply concerned about the proposal by the coalition government to amend Section 58 of the Takutai Moana Act to make sure customary title is issued on very few areas. These changes have left us incredulous and in turmoil. We have spent nearly 6 weeks in court process recently over May and June, with closing submissions due in October. During the specific part of our hearing recently, we had literally a busload and cars of between 50 and 70 of our people every day, because we have been working on this for many years and many months. This is not a process that we really relished going into, but is one we felt we had no choice, and we threw ourselves into that in good faith. This, as you will know, these processes have very, very intense feelings among our people. We're a pre-settlement iwi, and therefore everything we do requires a lot of time and effort for our people to get to grips with what is going on. So I guess on behalf of our board and our leaders at the moment, there's a question for how do you think it feels to be an iwi leader in these times when you've spent quite a while getting people to support going through this process that we didn't want to do in the first place, and then to find incredulously we're in this position where the Crown will simply come in and say it's going to completely change the law. It's unacceptable. We've had a lot of legal advice on how we should approach this and what we should expect, and we literally never expected, as I say, that the government would come in and say it's going to change the law completely. Sadly, we've had some recent history with these kinds of things. In the last few years, in the previous government, the National Policy Statement on Freshwater Management excluded Horowhenua and Jess Pukekohe. That was a situation that we feel is very similar. It's like history repeating itself, where at the last minute, the minister came in at the very last minute before legislation, couple of hui, bit of a drive around, very little detail, promises of a work plan, everything would be okay. And the next minute we knew, after decades and decades of our people's work for bottom line standards to improve our lake, which is the second or third most polluted lake in Aotearoa, were exempted for 10 years, maybe more. We ended up taking that case to the High Court and then to the Appeal Court, which we won. Hence for us, and why I'm standing here, this is unacceptable for us to be facing that uncertainty in what's happened now. I hear in the previous questioning that there is a Supreme Court hearing that might change the test for CMT anyway. Yes, that's true, but all along we've been confident that we'd at least get a fair process in front of the court. This is completely unfair for the Crown to tell us everything's going to change just because it doesn't like the idea of us getting the ability to control resources across our coast. This coast was the highway of our tipuna, even into modern times. And we find it ironic in the Horowhenua that we are asked to be intrinsically linked into the development of the Otaki to North of Inn highway for the good and the benefit of all, while we're not allowed to be able to look at, under this legislation that's proposed, how we protect and support the highway of our tipuna. This is particularly egregious. I took all what the last speaker said, and that is really the purpose of me turning up today. Made it through some pretty tricky weather on the way through, actually. A few of us had to stop on the road. But I'm here on behalf of our people and our leaders to voice our extreme concern at how egregious and incredible this is.
All right, thanks, Ms. Rump. And can I just, before you answer questions from the Crown, can you just ask you about a change in your evidence, paragraph 17. We had a chat about this. So paragraph 17, Sir, refers to an RM point. You know, if they had better lawyers, this would have been this wouldn't have made the cut. So, Ms. Rump, I understand you want to have that paragraph struck because it's wrong about what the change will be to the coastal marine
So,
permits.
as you've said, my lawyers have looked further at this, or our lawyers have looked further at this point of law, and they suggest that paragraph 17 of my second affidavit should be struck off. And kōrero with our board, they observed that it was a good thing when people recognise their mistakes, as with this legislation, and amend them accordingly.
Thank you, Ms. Rump. If you remain there for questions.
Mr. Stevens.
Thank you, Your Honour, and tēnā koe, Ms. Rump. I've just got a few questions. First of all, in your evidence, and I'm referring to your second affidavit of the 7th of August. You got that one handy?
Yes.
And you explain how Mōpuku's MACA application has just been heard by the High Court.
Yes.
16 May to the end of June. So that is, as you say, an undetermined hearing, and the effect of the proposed amendments is that that application would have to be reheard under the restated test.
That's my understanding, yes.
And you explain the effort of presenting evidence and attending the court yourself and in your whanonga, in terms of busloads of people coming down for the hearing.
A busload with cars.
A busload with cars.
Yeah.
You mentioned also in your evidence today that you're aware of the Supreme Court case involving Edwards.
Yes.
And that the Supreme Court could change the law and reverse the Court of Appeal on the test.
Yes.
And there is the prospect, I suppose, of a rehearing of your case in that context.
Yes.
And that type of rehearing would involve the same consequences in terms of having to duplicate the effort, go to all of those efforts again.
Yes, that's true.
Assuming that the Crown makes changes to the legislation in the manner proposed, given the impact that you describe in terms of rehearing, I wanted to ask whether you think there are any measures that could be taken by the Crown to mitigate those impacts, to reduce them?
I think there's a couple of things. For whānau Māori, the journey is as important as the destination. So with the Supreme Court hearing that is scheduled, we would see that regardless of the outcome, that there would be a fair process that we would be involved in. So that in itself would help our people make the journey, whatever the outcome. As far as the mitigants, we have so little information and detail about no options, no wording, no detail. It would be impossible and unwise of me to even attempt to answer that question in front of the tribunal today. And I say that because of the learnings from, the National Policy Statement on Freshwater process, where we leapt into a wee bit of ambiguity in the unknown and good faith, and it has been a shocking experience for us as iwi leaders, because our people have virtually said we're kupapa Crown agents. So I'm very reluctant to even go there with so little detail on record for us to respond to.
The criticism that you're talking about in terms of being kupapa, are you referring to the MPSFM and the process there?
Yes and no. I don't want to go into too much detail, but history started to repeat itself through this process too. So as I say, I'm sure all iwi will agree, it's pretty intense, and we choose to be there, but it's pretty intense to be in iwi leadership at this time when we've got, for us particularly, we've got examples where we've entered in good faith. Very recently, it went horribly wrong, and apart from this being such an egregious proposal from the Crown, that's what we face into in this example, again.
Yes, and I can see in your evidence that you are very critical of the consultation process, or lack of one, in relation to these changes. And one of the points that you make is that you say you don't have enough information about the proposed amendments. And so I wanted to ask, what is the information that you believe you need in order to be able to engage properly on the subject?
I think a proposal based on what you think that we would need to know, and you've had more experience than we have in these things. So a proposal on what some of the detail is, some of the proposed wording, the options, any detail.
So there is the pānui, obviously, of 25 July, and which sets out the key measures that are proposed for amending legislation.
Too high level.
It's too high level?
Yeah, we need a proposal. that we can sit down and consider.
In terms of a consultation process, how much time do you think would be required, or is that too hard to say?
Depends on the proposal.
Yes.
But once we see that, we'd probably be able to answer that question better, particularly given our experience with the National Policy Statement on Fresh Water and, you know, how that's informed what we see as required for better consultation in the future. And remembering that for Muupago, I'm not here to represent the private owners of Lake Horowhenua Punahou, but there are those extra stakeholders that we would need to be able to involve.
Do that, in terms of those extra stakeholders, does that relate to Takutai Moana? Because you're referring to Lake Horowhenua,
yes,
and I'm assuming the trust. And
yes,
the
I'm not the expert, but I'll go so far as to say that under the Rolled Act, yes, it does.
Okay. Last question is how do you say engagement should happen once you have the information that you say you need?
Probably need to look at that when we get the proposal, but in the normal way, which is a mixture of hui, we would need to be able to consult with our people and have time to do that.
Thank you, Ms. Rump. Those are all my questions. Ngā mihi
Kia ora.
ki a koe. Thank you, sir.
Tēnā koe, Ms. Rump. Thank you for your evidence. We don't have questions for you, but I'll just check whether Mr. Benyon has any re-examination.
No, sir, no re-examination.
Kia ora.
Tēnā koe. Thank you for your
A
evidence.
waita.
Certainly.
I understand.
Aneira taku aroha, aneira taku ngako, pere mai tatana kio, api apitia, aneira. Api apitia aneira. Kia ora.
Kia ora, Your Honour. We're at the mercy of Air New Zealand at the moment. What we would propose is that we break early. We're expecting that everyone will arrive over the lunch break, and then we perhaps have a longer session following lunch with some micro breaks built in to make up the time that we might otherwise lose.
So, Mr. Lyle, I'm happy to be flexible to try and accommodate the travel arrangements. I am being told that Kai won't be here for another 15 minutes. Are we able to make a start on any other witnesses in the meantime, or?
I'm not sure that we are, sir. I understand there's a plane which has Dr. Panaho and it has some of the rōpū from some of the other witnesses, which should be landing about now. So that's the.
Okay, so if we adjourn now, what time are you proposing that we return?
So if we were to come back at 1, I think we'll be able to complete what we need to today and start afresh tomorrow.
Okay. Thank you, Mr. Lyle. We will take that approach, and then hopefully from 1 o'clock all witnesses will be here and we can proceed more smoothly this afternoon. But thank you, Council. And also Ms. Rump for what we have heard so far. We will adjourn and we'll reconvene at 1 o'clock.
patience this morning. Dr. Joy Panaho has been able to join us now. The Air New Zealand stars have aligned. Dr. Panaho, could I, before we begin, just confirm you've filed 3 pieces of evidence for this inquiry, Y2603B1, which was the evidence which addressed both funding and the potential changes, and then Y3400 A41 and A50. Could you just confirm that you have those with you today? And you just need to press the button on your microphone. It's just at the base there. And do you confirm that that evidence remains true and correct as of today's date to the best of your knowledge?
I do.
Ka pai. Now, the way that we're operating in this urgency is that we're going to allow for a short mihi or some introductory comments from you, and then my learned friend over here for the Crown is likely to ask you some questions, and then the panel may have some questions too. And then at the end, if anything's come up that I need to re-examine you on, I'll pop up and do that then. So
Okay.
I'll pass the time to you, Dr. Panaho, if you'd like to do your introduction.
Kia ora, Bryce. Kia mai tātou katoa, ngā mihi nui kia koutou e te iwi, i ngā roia, me te kai whakawā o tēnei rā. Ko ai au, ko patuhare keke me te uriroroi, me te parawhau ngā hapu ki whāngarei. E te taha o te toko pāpa, Henare Hohepa Pānoho was my father. E te taha o te toko mama, Lily Pānoho was my mother. She was from London. We were born and raised on our land, which is in coastal Whangarei, South Whangarei. So, and kia ora to our whānau as well on Zoom. So, tēnā koutou, tēnā koutou, tēnā koutou katoa. Yeah.
Now, if you'd like to take 1 or 2 minutes to orientate the tribunal with your evidence, and then we'll move into questioning if that's okay with you. Bye.
One of the areas we feel particularly aggrieved about is the coalition agreement, where they aim to reverse measures taken in recent years which have eroded the principle of equal citizenship. And the reason we're aggrieved about that is, where is the assumption that equal citizenship existed in the first place? I study organisations, and I study post-colonial theory, and I study the development of organisations and org change. I've been involved in an affirmative action plan, and never have I before ever seen so many upset people. It doesn't matter what data you present, it doesn't matter what the evidence is, people just get affronted if they in any way think that they're giving us more than they already have themselves. So I think that we've suffered for decades with erosion of power and control of our lands, and this is just a continuation of the same thing. Based on a false notion, really. If they think that they're giving Māori more, then they really need to examine what they're giving themselves. It doesn't matter how much evidence there is, people won't move from that position. So, I guess that's why we're here today.
Ka pai. Well, with that, I'll pass it to my learned friend to ask you questions, if you're comfortable there.
Yep. Kia ora, Bryce.
Tēnā koe, Dr. Panaho. I've got questions about both of your affidavits. So the first one is your second affidavit. Sorry, two out of the three affidavits I've got questions for. The first one is the second affidavit that's dated 9 August 2024, and that's A41. You say there at paragraph 6 that you want to be very clear with the tribunal that the MACA Act itself is something that perpetuates post-colonial violence and trauma against Māori. And so my first question was, do you mean currently as unamended?
Yes, yeah.
So how so?
I use a theory of colonisation that explains that the violence that occurs at the time of colonisation is the founding violence, but isn't the end of the violence. And in fact, that continues on through the establishment of our nationhood. So when we look at the MACA Act, all of a sudden we were in a situation where we were having to say, I relate to you, or I don't relate to you, or you're going to take something that we believe is ours. This is amongst our own hapu. So that in itself is divisive.
So the very process that the legislation sets up in terms of establishing customary marine title, for example, is part of ongoing colonisation. Is that the way to frame it?
Yes, it is. However, it's all we have, and it's better than nothing.
Well, yes, because that probably goes to my next point, is that you say at another part of your evidence that you saw an ember of hope within the MACA
Yes.
Act. And I just wondered what that was. What was the ember of hope that you saw in the legislation?
It probably relates more to our journey through our land and our whenua and the Takutai Moana. So we have not had legal access to our land, and it was an omission on the part of the Crown. So we've fought for that for decades, and it's just been part of the process of finally seeing that we now are being recognised and have access to what we believe are our customary rights.
I see. So the legislation in 2011 did represent some kind of progress in terms of the fight that you had been carrying out for decades.
It's never perfect.
Yeah. So your MACA application was heard by the High Court earlier this year?
February.
Yeah, February to the second week of May. So that's the Whangarei Harbour hearing.
1A.
1A, yeah. And then at paragraph 13 of your evidence, you explain that that's an undetermined hearing. You don't have a judgment as of 25 July. And so under the proposed amendments, that would mean that your application would have to be reheard according to the revised test.
Mm-hmm.
And you make the point that having to rehear the matter will have a very serious impact in terms of time and stress and relationships with your whanaunga.
Mm-hmm.
Got two questions about that in terms of the nature of those impacts. The first question is about the availability of evidence if there were to be a rehearing. I think you mentioned that you've got evidence. You got evidence from Anthony Patete
Mm-hmm.
as an historian, but then also members of the hapu would be
Whānau, yeah.
of whānau, that's right, would need to give evidence again. And is there a concern about availability? Because you mentioned at one point poor health, those types of matters. So is there a concern about the availability of evidence from some witnesses?
There's always a concern. We don't have endless resources.
Yeah.
My brother is dead. My sister's dead. My cousin who put this application in is so unwell he can't walk.
Yeah.
So this is equal citizenship. No. It's not. There's always concern about how much energy we have and the resources that are taken from us.
So it's a question of energy and the need to go through it all over again, and then there are actually witnesses that might be unavailable because they've passed or otherwise.
It's also tikanga. It's insulting.
Yeah.
to feel that we have not been taken seriously in the first place. We entered into the process, expressed our concerns about it, but participated nonetheless.
Are there any measures that could be undertaken by the Crown to mitigate any of that?
How do you repair trust? How do you repair trust?
So is that's no, there's really nothing that can be done?
I guess it depends how much mistrust you have in the first place, and we've had a fair bit. So, and everywhere we see around us, our identity is eroding. It's, this is part of a campaign, basically.
Okay.
So how do you address that? Can you suggest something? Can you suggest something?
Well, the purpose of my questions is not for me to give evidence, I suppose, but to ask you what your perspective on these questions are.
Well, our perspective is we've had enough. We've had enough.
Yeah. Just briefly then on your evidence and reply, so that's A50, that's the 20 August document. And in that document, you're very critical of Te Arawhiti's advice to the minister, and you say any pushback such as it was is muted. And you put that down in part to a false notion of political neutrality.
Mm-hmm.
How is it that you say that advice should have been expressed to the minister?
You mean what should Te Arawhiti have done?
Done and said, yeah.
My expertise is in strategy, so I analyse strategy and policy, and I look at documents like the Statement of Strategic Intent and the Chief Executive's statement, and I look to see how that's implemented through action.
Mm-hmm.
And I do not see it implemented through action. Plus, there cannot be, quote, a neutral position that Te Arawhiti can hold. They're there to help restore the relationship between the Crown and Māori. How can they approach that with a neutral position? Why would they be needing to repair the relationship?
So coming back to my question, acknowledging what you say there, how is it that what's the way in which Te Arawhiti should have expressed the advice then to the minister?
I think they should have been firmer. Read the room.
Read this room, you mean?
Māoridom, what's been going on currently this year. They did mention it, but, a minister doesn't have to take advice. That's right, but if they were really there to repair and move the relationship forward, then they should have signalled more strongly that this was destructive.
So expressing matters in that way, is that would have moved, would that be designed to obtain a different outcome from the minister?
Well, yes. To say that you're from a position of neutrality is not possible anyway. How can anyone be neutral? We all have our opinions and views and experiences.
Neutrality, though, in the sense that that the views of officials aren't politically aligned with the government of the day. That's the point of neutrality that's being made, though, isn't it?
How is it neutral to align with the political aims of the government?
Well, it's not, and so that's my that's the point that I'm putting to you, that political neutrality is about not being aligned with the government of the day, but offering neutral advice.
I would imagine that they were hesitant to speak out more strongly.
Thank you, Dr. Panaho. Those are all my questions. Ngā mihi ki a koe.
Well,
Dr. Panaho, if Tarawhiti had have stood back and given options at one end of the spectrum, along the lines that you suggest strongly, that that there was a destructive consequence to what was being proposed. At the other end of that spectrum, identified that what the Minister was seeking was an option, but somewhere in between those, on that spectrum, identified other alternative options to address particular issues, if there were particular issues. Would that have met your concerns about the way Tarawhiti approached this?
primarily the lack of consultation is that, and that's not contentious, is it? Consultation? The lack of consultation was first and foremost egregious.
I suppose what I'm asking you is your complaint that the neutral office of Tarawhiti failed to look outside the box that had been given by the Minister and didn't address the spectrum of possible opportunities.
Yes.
All right, thank you.
With consultation being first and foremost.
Oh, yeah.
Thank you, Dr. Pānoho. Matua Pau and I don't have questions for you, but thank you for your evidence. Mr. Lau.
Kia ora, sir. I don't have any questions of re-examination for Dr. Pānoho, but thank you for your time and apologies for the delays.
Kia ora, Bryce.
Kia ora. Sir, I'll pass to Ms. Dixon.
Tēnā koe, sir. I'd now like to call Mr. Apirahama Kiripiti Edwards to the stand. Mr. Kiripiti Edwards has filed 2 briefs of evidence for this inquiry. For the record, they are A3 and A13. Can you confirm that you have those briefs before you?
Aye.
And do you confirm that that evidence remains true and correct to the best of your knowledge?
Aye.
Thank you. I'll now hand the time over to you to introduce yourself and then I'll ask you a few questions.
Ka pai. Hoino ka tō wai anō I ngā mihi o te ata nei, ki te aroaro o te whakaminenga, e mihi atu ana kia koutou ngā mema o te rōpū whakamana I te tiriti o Waitangi. O tira tātou katoa, kua hui hui mai nei ki te pane o te motu, ki te upoko o te hika, ki te kōrero, e pāna, ki te take o te rā. Arā ki taku titiro ko te mana tuku iho, a te ao Māori, ki ana taonga, arā ki te papatai moana, ki te moana no hoki. Taku ingoa ko Apirahama Kiripiti Edwards, he nui aku kārangarangatanga iwi, kārangarangatanga hapū, hoino kei konei ahau, hei whakakanohi taku rahi o Ngāti Wai. Taku iwi o Ngāti Wai, he iwi moana, I whakataukihia. Wō mātou tūpuna mātua, I he tahi o ngā pepeha a Ngāti Wai. O tira ngā pepeha o tō mātou tūpuna a manaia. I pēnei tana kōrero, aha kua tū anā hau ki uta, e taupunga ana ki tai. Ko te tahi atu kōrero mōna, kia tūpato I nā korikori koe I ngā one o manawahuna. Kei pāhe āwha he marangai, ngā puke ahu o manaia. Nā, enei kōrero e rua e whakaatu ana i te hohonutanga o te hononga o taku iwi o Ngāti Wai ki te moana, o tira ki te papatai moana, ki te tai ao moana. He ko atu i te hononga kiko kiko, he hononga tapu, he hononga whakapapa, he reki ake ana a Ngāti Wai ki te moana, ki te papatai moana. Taua mana tuku iho no mua i te tiriti o Waitangi, no mua i te whakaputanga, no mai anō i te oroko hanganga mai o tēnei au e aiki a Ngāti Wai. Nā re mihi atu ana ki a koutou katoa.
Thank you, Mr. Kiripiti Edwards. Can you please explain the position of the Ngāti Wai Trust Board in relation to the MACA Act?
Aira, ko roa Ngāti Wai e noho āwangawanga ana ki tēnei ture. Ko roa Ngāti Wai e noho āwangawanga ana ki tēnei whakaaro, kei a te krauna te mana, ki te kōpau, i ngā mea me whakatutuki e Ngāti Wai, kia whakaihia he mana tuku iho tonu tāna ki runga i te papatai moana, ki runga i te takutai moana. Nā reira, ko roa mātou e āwangawanga ana ki te pūtake o tēnei ture, ahatia koia i kuhu mātou, kei riro hoki.
In your evidence, you talk about your attendance at the National Iwi Chairs Forum. Can you explain what your role was there?
I reira hau i te mea ko hau te hea mana o te runanga ara te poari o Ngāti Wai. Nā rea i kona hau ki te whakakanohi taku iwi i roto i tērā huihuinga hea mana a iwi.
And how did you come to discuss the MACA Act with the Minister?
I whiua mai he rua te kau miniti kia noho te minita ki te aroaro o ngā hea mana o ngā iwi o te taitoke rau. I reira hau e noho ana ki te tepu. E tatari atu ana kia rongo i ana kōrero. Te tae ngā ke kahori au i tino pai ki ngā kōrero i puta i te minita, a ka whāki atu au i oku whakaharo.
And what was the outcome of your kōrero to the Minister?
Taku kōrero ki te minita, e kore rau atu a Ngāti Wai e whakae. Kei a te krauna te mana ki te whiriwhiri, i te hohonutanga, i te whānuitanga, i te whāititanga raini o taku mana tuku iho, ki te papatai moana, ki te takutai moana. I mana, taua mana tuku iho mainoi o mātou tūpuna mātua, heke tonu iho ki a mātou, ka au tonu i roto iho mātou uri whakaheke. Aha koa ko wariwari pēhea nei te ture, mana tonu ana e aiki a mātou tō mātou rangatiratanga, tō mātou mana tuku iho ki te papatai moana.
You say in your evidence that there was a distinct and consistent kōrero shared amongst the Tai Tokero leaders at that forum. Can you describe what their views were collectively?
He ko atu i te āwangawanga, he hoha, he riri, he pāpauri, e rā ahuatanga katoa. Ki tā mātou titiro, he raupatu anō tēnei mahi.
Thank you, Mr. Kiripiti Edwards. I now invite you to remain for questions from my friends and from the tribunal.
Ngā mihi.
Tēnā koe, Mr. Kiripiti Edwards. I just want to ask you some questions on your brief of evidence of 7 August 2024, and that's A13. And my friend has just actually asked you questions about this herself. It involves you meeting with the Prime Minister and Minister Goldsmith, and the subject of proposed changes to Section 58 of the MACA Act came up. And you say in your evidence that you were appalled at what they said about the proposed changes, and that was because Minister Goldsmith said that the Court of Appeal had recently changed the threshold, and it was important to get the balance right. So I know you wouldn't have agreed with that, but why do you say you were appalled by that statement?
Nā wai teka kei aia te mana ki te whakarereke i te ture ko i anake. Ka hore he kōrero, ka hore he aha.
So it was the fact that he was saying that he intended to change the law and there hadn't been consultation about it that was the issue?
E ko atu i tērā, kei hea te whakaute ki te tino rangatiratanga o ngā iwi o ngā hapu i roto i tērā tū whakarereke i te ture. Ka mutu, ko te ture neki e hāngai ana ki a mate.
You also say that Minister Goldsmith talked about the importance of the marine aquaculture space and that you thought that was really unfair. Why was it that you thought that it was unfair for him to talk about marine aquaculture and the importance of it?
E ko te whakaaro i roto i au e, ko ia ki te toha toha, ki te whakarite i te ture e toha toha e nai. Ngā wāhi e tūai, e nā tūmahi ki te papatai moana, ki te takutai moana, ka hore he wahanga, ki ngā iwi, ki ngā hapu, i roto i aua whakarite i aua whiriwhiri. Kei hea te wahanga ki te tino rangatiratanga o ngā hapu, ki runga i tēnei taonga.
So was that a specific thought in relation to marine aquaculture?
Kia au ki taku titiro, he orite te pūtake o enei nawe, enei āwangawanga e rua e whakamara mātu ana hau ki a koe.
I see. You also relay that you went on to challenge his kōrero by saying that the government didn't have the ability to define the threshold for Māori to have their customary rights recognised. And I think you're saying that again today in your kōrero. What do you mean by that? Do you mean that the government of the day doesn't have the ability to define the threshold at all? Is that a point about tino rangatiratanga? Or is it a point about consultation?
Ngā mea e rua.
If it's about tino rangatiratanga, is there a space where there's a solution in relation to that? Are you saying that there should be no act at all?
Mai rānoa ngāti wai, whakamara mātu ai, i wō mātou āwangawanga mo te wahanga ki te ture. No nāhea te krauna whiwhi ai te mana ki te whiriwhiri, ki te tātari, i te whānuitanga, i te hohonutanga, i te pāpakutanga raini, o taku mana tuku i hoki te moana.
Last question is about the consultation process, and you're obviously very critical about that. And you say that at one point you say that consultation has to happen at the kāinga level. How feasible is that? What would be involved? You know, how would that work in practical terms to consult at the kāinga level?
Ka hore te tino marama ki tō kātai.
Well, you say that consultation needs to happen not at an iwi level, not even at a hapu level, as I understand your evidence, but at a kāinga level. That's the type of engagement that needs to happen. And so there would be a very large number of kāinga with whom to consult. And so my question is, how long would it take, how feasible would it be to carry out a consultation of that kind at that level?
Well, it will take as long as it needs to take for an honourable decision and process to be established and determined. Ko ēnei mana e noho ana ki ngā kāinga, ki roto i ngā hapu me ngā iwi. Ko ngā whānau I runga I te whenua e noho ana, I ngā kāinga e noho ana me whai wāhi rātou ki roto I ēnei whiriwhiringa. Pēnā koe te karauna e whakarite ana I ngā pauaka me o rātou ki roto, kia mana e wā rātou mana tuku I hoi roto I te ture, me whai wāhi rātou ki aua whiriwhiringa. Engari e mea nau ka hore tēnā I te tika. Ka hore ia te karauna te mana ki te whiriwhiri I ngā pauaka, me kuhu ngā whānau, ngā kāinga, ngā hapu, ngā iwi ki roto, e mana tonu ai rātou, e mana tonu ai ā rātou hononga ki ngā taonga, whakarere I hoi o mātou tūpuna mātua ki a mātou.
Are your views, are those views about consultation, is that specific to takutai moana, or is that a perspective about consultation with Māori generally?
Well, e kōrero ana tāua mo te wahanga ki te takutai moana. Nā reira koia.
Tēnā koe, those are all my questions. Thank you.
Amen.
Hei te rangatira, kua pānui I o kōrero. E ngani e whakahoki ana o whakaaro ākene kua kōrero ke tia anō e koe. Hea hato I wiki ai ko Ngāti Wai?
Whakahuatia Ngāti Wai ki tāna ingoa, nā roto tonu I taua hononga, taua herenga ki te moana. He iwi moana a Ngāti Wai. I mua atu I tēnā, ko te ingoa o Ngāti Wai, ko Ngāti Manaia. Engari nā o mātai tūpuna te ingoa I tahuri, I roto tonu I ngā kauenga tapu a o mātai tūpuna mātua e pāna ki te waitai moana.
Nō reira, e hara I te mea e pānoa ana ki te wai Māori, e pāna hoki ki te waitai me ngā wai katoa o tōrohe.
Aira.
Nā, ko tētahi mea nui ki tōrohe, me nā koe he tangata moana, ka mutuko tō ingoa ko ngā tiwai, ko te manaaki I o manuhiri. He hanga kai rangatira, ka hora ina e koe ki o manuhiri, hai whakarangatira I a rātou?
Kei te wahanga o te tau e tohu mai ana, he hanga kai. Engari ko ngā kai o te moana, ngā manu tai, ngā manu o te moana, ngā kai o te moana. He iti noa te ngahere I roto o Ngāti Wai. Ko te pātaka kai o Ngāti Wai, moana. Whakarite hia, ahau e kōrero nei, mo te whakahira-hiratanga o ngā kāinga. Nā te mea ko te tahi o ngā ingoa I whiua ki runga o Ngāti Wai, ko te ākauroa o Ngāti Wai, me ona tini kōpiko-pikotanga. Ko aua kōpiko-pikotanga ko ngā kāinga, nā e tūhono-hono ana ngā kāinga, māroto tonu I te wai. Me ngā mautere I waho I te ākauroa, a Aotea, a Hauturu, Marotiri, Taiake ki tawhiti rahi, ki Aorangi, me te moana e hora mai ana I waenga nui te ākauroa me aua mautere, anō nei he marae. Taua horanga moana, te wāhi tūtaki-taki ai ngā hapu o Ngāti Wai, I roto I ngā tau, a haere tonu ana ki tēnei rā.
Nō reira, te ahua nei, ki taku whakarongo atu, ko te nuinga o kai no te moana, he ngahere iti kai tōrohe. Ki te kore koe whai wāhi ki tō moana. Ka tae atu ai he manuhiri māu. Ka kore ai e taea e koe. Te tiki ngā kai o tō moana hei whāngai I o manuhiri. He pēhea te mate o tō mana.
Kāhinga ki raro. Koe nei mātou e āwāwanga atu nei. Ngari e ko atu hoki I tērā. A wāhi tōhi, ngā tamariki, me he tahi atu o ngā kawenga, tapua o mātou tūpuna mātua, katoa e hono atu ana ki te wai. Nā rongo koe I ngā pūkōrero, I ngā tohunga o te kāinga pērā ia te haupeke I te wā iaia. Ka whakamutua ngā taku karakia ki te kupu e meana turuturu ātai, turuturu āuta. Hako e aha tana taku ka whakakapi tērā i mua i te huri ngātu ki te whakakapi tonu. He tohu tērā ki te hirahiratanga o te hononga ke āwairua tonu a Ngāti Wai ki te moana. Ki ngā kore Ngāti Wai āhei ki ngā kai o te moana hei whaangai ki o mātou maniwhiri. Ko te mana o Ngāti Wai tērā ka taka ki raro.
Ko tō mana, ko tō maui. Kamate.
Kia ora.
Tēnā koe, kia ora. Ko maro.
Tēnā koe te rangatira. Kaore aku pātai, engari tēnei te mihi ki a koe ai au kōrero mai a kia mātai.
Tēnā koe.
Tumi.
Questions of re-examination for you, Matsua. But I just want to thank you for your evidence and for making time to be with us today. Ngā mihi.
Ngā mihi. Kia ora koutou.
E peki taua ki te tihi o
Hauturu mui o ka mataki taua ki ngā poeto te kupenga o toi te huatahi e tamatangi ki noe. Ka tira e tātou mā, kia ora tātou.
Kia ora.
Tēnā koe te kai whakawa. E whaikane te kōrero o te Mr. George Matthews. Because we relinquished our time for opening submissions, Mr. Matthews has asked whether we'd be able to give a brief kōrero just to give a iti background to his haringa as a MACA applicant. It won't be anything more than 5 minutes before he comes for pātai. E pai ana?
Yes, pai ana.
Pai ana. I'll approach the stand for it and then I'll ask Mr. Matthews to come up after that. Ngā mihi, sir. Kia ora, sir. Tuatahi, e o kui rangatira o te hika o Papaumua, me Mr. Matthews, kua tā mai ki tēnei hui hui, e riri ana ngā mihi. Ko Mr. Matthews he kaikireme mō te tono o te hika o Papauma, i raro te MACA. Kua whaiwhai a Mr. Matthews mō nā rangatiratanga o te hika o Papauma i roto te moana mai i te tau 1994 i tukana ai te kireme Y420 ki te naenei. Te hika o Papauma is an ancient iwi based on the isolated eastern Waitarapa coast north of Castle Point. And they trace their whakapapa back to Kupe through their lineage to their tupuna Papauma. They're one of several iwi that are currently in the position of having finished their MACA hearings in the High Court under Justice Gwyn, but with no judgment yet released for the 1B section of the Waitarapa hearing. The Waitarapa hearings that they took part in were extremely lengthy, and they sat from September of 2023 on and off and finishing in May of 2024. So with the current announcement by the government, that hearing will be overturned with the judgment by Justice Gwyn when it's released. And the overturning of this judgment will mean for Te Hiko o Papauma, the uri of Te Hiko o Papauma, that all the mahi that they put in for that hearing may amount to nothing. these claimants say that it's extremely prejudicial for them to have gone through all that mahi, to have dragged themselves all the way from the isolated Eastern Wairarapa to Wellington to attend the court hearings. Many of them are elderly, kaumātua and kuia, in and out of hospital. They spent hundreds of hours preparing evidence, negotiating with their overlapping claimants, negotiating mandate for the application itself, and to overturn that for them is unconscionable. E pūroa ana hau te kōrero o taku hoa mahi Mr. Hockley, he maumau tangata, he maumau wā, he maumau pūtia, ko te mea nui he takahi o te Māori o ngā iwi Māori, me he haora o te moana. It's the belief of Te Hiko Papauma that these amendments will leave the MACA Act as essentially nothing more than a mechanism to legally extinguish the customary rights of Māori in the takutai moana. The Crown, acting under their own view of Parliament's intent and against well-worn constitutional conventions and the rule of law, is justifying these acts under the veiled justification of balancing the rights of all New Zealanders, despite the fact that the original act was designed with that in mind. And although the Wairarapa coastline, the kāinga of Te Hiko Papauma, is extremely isolated, the area is subject to many overlapping claims, intersecting interests between hapu, and it's also an area of significant commercial fishing, an issue that was sufficiently discussed by the seafood industry lawyer at the Wairarapa hearing. So for the claimants, they say tuatahi, it is prejudicial that they'll have to return to court after essentially 6 months of hearing, and tuaroa, the amendments to Section 58 may mean that their claims will end up failing because commercial interests have been placed above their interests as tangata whenua. Mr. Matthews, I'll now call you to the stand to answer any pātai from the tribunal and my learned friends. And I'll address you regarding your affidavit from over there. Nā mihi te kai whakawa. Kia ora, Mr. Matthews. Ano iriri ana nā mihi, kua tā mai ki tēnei hui hui. I tāwhiti mai. Before we begin, could you please state your full name and confirm the contents of your affidavit, which is appellation number #A14, which was signed on the 7th of August 2024, and that the contents of that affidavit are true and correct?
Ai. Tēnā koe e te tepu me a pūwananga ngā rangitira o te ao, e whakarongo te kōrero a ngā tiwi katoa o te motu kua tae mai nei. Ngā roia o te korona, tēnei takamii ki atu. Ngā kaitiaki tūturu o te taku taimoana kua tae mai nei, tēnei takamii ki koutou. Tēnā koutou, kia kaha, kia kaha. George Matthews is my name. I'm an uri of our kui Papauma, resided about 1500s, around there, and she, as you've heard, she whakapapas back to our tupuna, Kupe. So, yeah, I stand and I just take my evidence as being read, and happy to endeavour to give some comforting answers to whomever.
Mr. Matthews, could you just confirm that the contents of your affidavit are all true and correct?
To my best and
Best of your
understanding,
knowledge?
yes, to
Yes,
my
ka pai.
that is.
Nā mihi matua, ka te matata kōrero.
You'll see a date in my evidence here, 1994, was when some Americans actually came and drilled a hole in the seabed off our coastline. It actually started in 1992. I heard about them coming. I wrote to the minister after 2 letters of correspondence. He suggested that I get legal counsel. And I don't know what he meant by that, whether I was just a bit bloody dumb or whether it was too difficult for him to handle. But that was the start. At the end of the day, when the sun set, the Americans came and dug a hole in our seabed, 12 k's off our coastline. And that was distressing. There were only a couple of us standing on the wet sand of the beach at home doing the haka. A lot of my relations were saying, boy, my uncles mainly, boy, what are you doing? These people, if they strike oil, they're going to build a refinery at Castle Point, or Rangi Whakahoma as we call it. And it'll be jobs for all of us. Now that's an old movie, I told my uncles. We heard that in 1840. Sell your land and we'll all get jobs. So I didn't buy that. So a cousin and I, we basically stood on our own on the beach. We pushed the Americans to a full-blown hearing, much to the embarrassment. In 1992, right? The RMA was brand new. The regional councils were still working out their computer systems, let alone dealing with Māori issues. And so they had no time to talk to us. We were probably just a little step ahead because we had read Section 6 of the RMA and we were standing hard on it. But we lost. We lost. And there's a big slab of concrete sitting on the seabed just off our coastline now, and it's been sold because the Americans that came, they were what you call wildcat drillers. And they struck oil, but we knew it was there because we knew about the gas that was leaking out in all the puna in our whenua. You could see it bubbling. You could throw a match at it, it'd burn. Hunters still do that now because they know where the natural gas is permeating out of the ground. And so we knew there was oil there. They came, dug their hole, quantified the oil and the gas, and on-sold it, which was their job. It's sitting there. Just as a matter of interest, at that time, Brent crude oil, which is what this country runs on, was selling for $12 a barrel. So I'll just leave it at that. I'll tell stories. I've got to stop.
Tēnā koe, Mr. Matthews.
Tēnā koe.
So I think I heard this in the kōrero of your lawyer, but your application is the Eastern Wairarapa application for which judgment is pending.
Aye.
And you had a hearing that was on and off for about 6 months?
Yes.
That finished in May of this year?
Yes.
In your evidence, at paragraph 42, now do you have that handy? It's, I can tell you what the document is.
What page is that, mate?
So 7 August is the date. It's A14. And paragraph 42 is...
Yes. Yes. Certainty.
Yes, and then you have a set of questions there. And I suppose my question was, are you saying that you don't think the public material, the pānui that has been put out, adequately answers those questions, that you're left in doubt about them?
That's why I'm doubtful about it. My answer is no.
Okay. You do refer, however, to the prospect of Te Hika or Papauma having to relitigate all over again.
Yes.
And that is the basic effect of the proposed amendments for Māori who have an undetermined judgment, that there will need to be a rehearing according to the new proposed test.
You make it sound very simple. The basic effect.
Yes.
It's a huge effect.
Yes.
It's overwhelming.
Yes.
And it's based on 3 terrible poisons we all carry in our mind. Greed, anger, deceit. And I'm saying that's what this amendment is based on, those 3 poisons. And so you ask me, oh, the little effect, yes. Yes, it's a huge effect on us. And I'm not going to say, oh, but, you know, we've been sat for 4 weeks in Masterton, and then we sat for 4 weeks in Wellington, and, well, why can't you do all that again? No, it's just disappointment. Anger that no one was looking at. And I'm going to say this here, Justice Gwynn is an excellent person, because you could see her actively listening, and she wanted to hear, and we were very lucky having her sitting at the top table. So she listened. There were other parties out there in our world that obviously don't listen. Do not listen. Yeah, so.
So hearing that the impact is extremely large if there were to be a rehearing.
Mm.
And you've probably heard me ask this question of other people already today. Are there any specific measures that you think could be put in place to deal with the impact of a rehearing?
To deal with the impact of a rehearing, oh boy. You know, I'm not the most righteous bloody person standing in this room today, but I will say, respect me and I'll respect you. Right? Speak to me, kānui ki te kānui, I'll give you the time of day. Abuse me, I'll abuse you. Okay, it's as simple as that. We've been abused. We've been ridiculed, we've been chastised. You know, I've always said to people this, and we've run into this, when you're speaking face to face with people, there's only one ngārara that you need to really watch out for, and that's a person that calls themselves a politician. You really do, because that's what's happened here. We were moving down a path, our families were hapu, and we're all coming together. We recognise the ngārara out in front of us there. We were working within process, the judicial process, even within ourselves, and all the dilemma and dynamics of that. And, you know, we're like any other iwi hapu. We don't all love each other all the time. We claim relationships and all our DNA is the same, but sometimes we can deal with each other. But all of that was coming together through understanding, through our tikanga. And it's not foreign. Tikanga is not foreign just to us. It's just basic in a lot of the value bases of kānui ki te kānui. And so, no, it was a big deception by this other party called politicians.
Where do you say the deception was?
I saw the deception in Goldsmith's proposal, conversation. I saw the anger that, oh, look, these natives might get a huge area of New Zealand out of CMT. I saw the deceit, and in the commercial fisheries conversation, and I saw the greed, sorry, in the commercial fisheries conversation, and I saw the deceit in Goldsmith's conversation.
What, just picking up on deceit though, what is it that you say is deceitful about what Goldsmith announced the Minister announced on the 25th?
The greed. His comments were sitting on a foundation stone of greed. And that is what created the anger within it. And there was a degree of anger from his side too. Hey, like I said, we can't let these Māori claim the whole of the country under CMT. That's the deceit. Or a korowai of the deceit. The shadow is there, yes.
And the greed that you're referring to specifically, what's that? Are you referring to the seafood industry meeting?
Yes, specifically, yes.
Right. I did ask the question before, and I might ask it again, which is, if there is to be a rehearing, acknowledging the impacts that you describe, is there anything you think that can be done to lessen those impacts or mitigate them?
A lot of our own people are going to just say, "Cuz, been there, done that, not interested." The same players, why would you jump in the ring with Muhammad Ali? I wouldn't. I'd get a hiding. I know that. Why would I jump in the ring again with some Johnnies that were deceptive, changed the rules halfway through, shifted the goalposts, all sorts of things, blew the final whistle or half-time whistle when I was moving forward, got through my hearing or the hearing. Why would, and they'd say, "Cuz, are these people worth really dealing with?" The take is important, no doubt about that. But, hey, we've sat on these hills for 500 years now. These Johnny-come-latelys have been here 180, and we have got the patience. Yeah. So let's just maybe sit on the hill a bit longer.
Okay, thank you, Mr.
Goodbye.
Matthews. Those are all of my questions.
Goodbye.
Thank you, sir.
Kia ora, Mr. Matthews. We don't have questions for you, but thank you for your evidence.
Kia ora tātou. Kia ora mai tātou.
I've got no questions. Oh, yeah. Kaore aku pātai mau. Yeah, kaore aku pātai mau. Thank you. E re rana ngā mihi matua.
Come on, too.
Ms. Hirawini.
Tēnā te kai whakawā o tira te tepu rangatira, I whakarongo mai nei. E mua te tū o enei kai kōrero ka haka mōhio atu e au te raupapa o tā rau tuku kōrero tira nei. Ko Mr. Nepia Ranapia he kaumātua no ngai te hapu o te mautiri o Motiti. Tuatahi rā ka tuku mihi a Mr. Nepia Ranapia hei whakataki I ētahi kōrero mō ngai te hapu. Muri ake ka tuku a Mr. Te Atarangi Sayers I ētahi kupu hakataki ka noho tonu ia te whakautinga pātai mai te karauna me te Tribunal Noki. Ka whakahiria ētahi whakaahua I te wā ka tuku kōrero a Mr. Sayers I kōrero atu ki te rehita I mua te timatanga o te rānei. I rungi tēnā nōku te honore ki te kāranga I a Mr. Ranapia rawa ko Mr. Sayers ki te tuku e te reo o ngai te hapu ki te ao. Tēnā kaurua, nei rā te mihi atu. I mua I te tuku kōrero ka whakau I te kōrero taunaki a Mr. Sayers. Tēnā koe, Mr. Te Atarangi Sayers, you filed... Sorry, I'll give you some time to stand up. You filed a brief of evidence dated 7th of August 2024 on behalf of Y2707, which is on the record of inquiry as A27. Is that correct?
Aye, tika.
Ka pai. Can you please confirm that the contents of that evidence remain true and correct to the best of your knowledge?
Aye, tika.
Tēnā koe, Mr. Sayers. Mr. Ranapia, kei a koe te wā.
Ko tā rā whakatau, whakawhāti, ko māmangi hea nā puke whāruarua, ki te pōtaka o te upoko karapu, ki te moana o tūhua. Ko tā raparapa ki te whenua te kōpū whakairi, ko mō titi rā tēnei, kāre wahi hai taukai. Ko te tokoroa kua hāngai tātau ararangi ko mō te nau hea. Ko te raparapa kua hāngai ki te tapatoru o te pū werewere ki Maketū. Ko te ara whakarere tange whai atu nei, ko te kupenga o ngā hutotarangi. Ko tau ki te papa o tai o kora miro. Ki ngā tauringa tai kukumi, i waho te moana ki te rere o ngā aturere. E tau ana, no reira. E rauranga tira mā, tēnā koutou ki ora tātou. A huri atu ke nei ki ngā whānau hapu tuarangi. Ia koutou, tēnā koutou ki ora tātou katoa. Ko tāku ingoa ko nei piarana pe he kau mātou no mō titi. Kai reira taku kāinga e noho anau. E ruta kau mā whātau on e noho ana i te rā mautere. Kai a mātou tunu tā mātou mana motu hake e mau ana. Ka rea no nā kauni here tai atu kera a Ngāti Hohai ki atu ana. Ka te mautuni a mātou. Ma mātou ka whakatūtū harea mātou a mātou whare. Engari ko nā koraua ai whakamana me ki ai anei me tūki konei o koutou kai. Ki hori atau ki te kōrero whakataura. Ko tā tauranga tai kukuku me kōrero nei tātou. Ko nā toka kai raro te hao te tai au, e raparapa hāre ana, i waho te mana o mō titi ara, kai rongi rā mahere e titiro nei tātou. Ko ngā tai e tūhonohono nei a rātau. We nā toka he kai chaki katoa kai roto i ara, kai runga i a rātau. E pupuri ana, kai tēnā, kai chaki, kai tēnā, kai te nuinga o rātau he wahine katoa. E pupuri ana nā wairua, nā Māori o tēnā o tātou moana. Ke piki atu ki runga te moana, ki ngā ngaru, ana ko te rerenga tērā o ngā aturere, e huri hāne ara, i nā toka mai tērā toka ki tēnei toka huri hāre ana, koina te pai roa o tēnā kai. Ara, kai runga tēnā i ngā mapire. Ana ko tērā kāinga, he te korowai o tērā kāinga, ko te papai o tai a kora miro. E tūhono ana, ki runga ki te whenua ki nā kai chaki, te kuia, ko te kōpū whakairi, kai runga i mō titi. Koina te kuia, ko puna, kia hau, ko māmā tērā. Ana koina, mahatunu nā kai chaki, kai runga tērā kāinga. I tuku atu au tērā, te timatanga o te kōti i tauranga. Ana ka huri tātou ki nā mapi ko ki te tātou i nā pā. E huri hāre ana, e tori te kau nā pā o tērā mautere. Mai te raki ka ki te koe we rā pā. Ana, e te tahe te pā, he mea paku ka te taha i a rātau, he mātai pau. He mātai pau ka whakatūhi a rātau, kia kite ai waho te moana. Mena ka te hāre te whānau ki te. Ki te moana, te tiki kai, ana ka tu atu rātau i runga ki te titiro, e pehana haere, ka te pehea te hau e pupuhiana. Ana mena ka te hāre rātau, ki te raki ki te hi, ko tatari rātau ke pupuhi mai te hau a te raki, a tahi anō rātau ka hāre ki te hi. Mena ka huri mai, ka mena pupuhi mai te hau, ko whakōkia mai rātau ki te kai. Koira te mana o tērā, wera marae e tūtū ana. Ana wera ka hare nā tamariki ki te kaukau, ana ko piki atu ki te tiro atu ka te pehea te whakaere. Tūra, ana wena te tiro rātau i ngā whānau ko ko tā mai te tio whenua, ki reira ko titoria rātou o ko tā mai mātou whanauka, mai maketu. A koira i tuatei rātou te mātaipau. Ai tērā mautere. Koira nā tuahauatanga o tērā mautere. Ana, me hoki tātou ki o mātou kaichaki, i te wā i pā te rena, ki rungi o Taiti. Ana ka aru te raruraro, ka heke mai kua tāna paru, wera tuahuatanga, mai te mautere ki te ākau o te tua whenua. Ana ka tā mai nā salvos ki reira, ki te whakatika hare, te tiki atu nā rāpihi. Ko rea hare ana, ko roa e hare ana rātau, ana ka puta mai he raru i reira. Ana ka he katoa nā mahia, ana salvos, ana ko tiru te rangatira, te kāpena o tērā, o rātau mā, ko ki te atu ai, he raru ka te haere. Me hare pia tātou te tiki nā Māori, hai whakatika, tā te mea ko puta mai he wairua. Ana ka hare mātou ko nā koraua, ka karakia mātou, ana kanu, ka pai. Ka kia tau ki nā Pākehā, ka te mōhia koto i tukino hia koto tēne toka koto e mōhiwan. E mera, ka puta mai no ne wairua, e ka hare mātou mo te hoki mai. Ko te koro ne e tuku atu nei kia koutou, i wahota mātou moana, i reira. Koina, mai rāno, ka haere rātou. I wa rātou whanau te tua whenua ki wēnā kāinga. He kāinga wēnā. He kāinga. Ana, ra kareki he rātou. Pera no mātou i te tā mai nā, hare no mātou ki te mahi kai te moana. Ka karakia mātou i mua te hare tangirata te wai. He hātera karakia, he whakatangu heatu ta wairua te whenua. Ka whakauri mai nā wairua o te moana. Ke tikai ta mātou hare, ke kore e tūkino i he mātou i waho te moana. Koira te mana, te Māori, e kore rene tātau. Ana, tuarua, he nana tuarua, te toka ka i reira kōra atu nei te kuia. Ka i reira, ka titiro rātau i te rā, i runga i te kaimai, hori atu. Ana, ka i reira te rā e hāre ana ki tōna haere. Ka tā mai ki te rā poto, ki te takahuri ki tōmui, ko hoki anō te rā. Ka tā mai wainga nui, ko te rā hupeke tērā. He orite ki te au, he ki te pō e ki ana wa tātou kraua. Ko te rā hupeke o reikihi. Ka huri hāre te rā, i runga i nā pai maunga, ka tai atu, ka tō te rā, ko tērā, ka huri te rā, ko te takahuri ki tōmuri tērā, ko te rā poto. Ka hoki mai anō. Ka hoki mai anō te rā, ki wainga nui, ko te rika o te rā tērā. Ka hoki hāre te rā, ka tā mai te mene amutu whenua. Ana koira te kāinga, i takote e rātau mā, ke kite hāre rātau, e pehea ana nā marama, nā takiwā, wera tuahuatanga. Ana koira, te mana, te Māori o tēnā mautere, ka kore he Māori, ka kore he mana. Anō reira, koine tāku nei, kōrero hei whakatau, hei tuwhera nei, whaku atu nei te rākau, ki tō mātou tama, ia atatarangia, hei whakatau e nei kōrero. Nō reira, e rauranga tina mā, tēnā koutou, kai raro tēnei.
Nā mihi ki te kaiwhakawā, ki te tēpū, o te whakamana, o te tiriti o Waitangi. Kia ora. For expediency and efficiency, I'd just like to just introduce briefly the highlights of my evidence, which is to just obviously was expanded on in terms of the background by my uncle Nepia and the interests in relation to the rohe moana, the concerns regarding the ignorance of the Y2660 report, which this tepu was part of, and the challenges that have happened in that we have been through our hearing, and now we are no longer, or we may no longer be able to, or we'll have to have a rehearing of our kōrero and kaupapa, and the sense of that steamrollering that's occurring, given that we've had such a short amount of time to now adjust without any consultation, and the impacts that will have on Ngāi Te Hapu and Ngā Hapu o Te Mautiro Mōtiti. Yeah, so I'll hand it to you or back.
Tēnā koe, Mr. Sayers.
Kia ora.
So, your High Court application was heard in the Ngā Pōtiki Reader proceeding in 2021, is that right? And judgment is still pending for that hearing.
That's correct.
That's a long time. Are you aware of any reason for the delay in delivery of the judgment?
My understanding is that our legal counsel have sent a memorandum post-hearing to Justice Powell in order to find some reasoning behind why this is taking so long.
But no answer or understanding in that regard?
I think the kaiwhakawā works in his own time.
Right, okay, thank you. You explain in your evidence how you spent several years leading up to the hearing, planning, gathering kōrero, tukuiho, expert evidence, and that some of your kai kōrero and kai tautoko who have expended significant time and energy have since passed.
Aye.
If there were to be a rehearing under the proposed amendments, you will have heard me ask this question of other people, whether you see any measures that the Crown could take up to deal with the problems that arise from having to rehear a matter, particularly where the hearing was quite some time ago?
I think there's many challenges with the idea of the rehearing process, given that evidence has been given, it's been tested, it's been challenged, it's gone through, I suppose, the evidentiary process that the justice system provides for, and given the lapse or the passing of time and of kaumatua and various other attributes, it's very difficult to comprehend what the impacts may be for the future generations that will have to pick up this new approach that the Crown is proposing. I suppose where we have such a distinct island-centric relationship, we will rise to whatever challenges come to us because we only have us. And therefore, in that sense, we will not just lie down and let this pass over us. We have an unbroken connection to Aotearoa through whakapapa and through intergenerational relationships. And the knowledge is handed down in our toka. As Uncle Nepia has just expressed, those associations, awarenesses are all inherent in our being, the way in which we relate to our rohe.
In your evidence, you're also critical of the consultation or feedback process that the Crown has run following the announcement.
Absent. There has been none.
Well,
I think at best, and I'll have to look to, I don't think we've received any consultation apart from basically being told to come here.
There was no consultation, as you say, prior to the
None.
None prior to the 25th of July. but then a feedback process following the pānui of the 25th of July that's run for 2 or 3 weeks?
Have no idea. It's not. We've been absent of that. I mean, arguably we're on an island.
Right.
Our whānau are on an island.
Yeah.
I mean, we have a copper line.
One of the things you say that you do want from the tribunal process is a strong recommendation that the Crown immediately stops all further progress of any bill until the Crown's undertaken te tiriti compliant process. What does that process look like? Can you describe that?
Well, I suppose it's kind of an interesting aspect around this idea, but if we start at the first principles of building partnership, building trust, I'm sure other witnesses have suggested that that's the first place to build a foundation. The Department of Conservation has a consultation development strategy that they engage in, which starts with pre-consultation, developing the models and the frameworks for how consultation may progress, and into what pathways may be appropriate for the time or the kaupapa that's been discussed.
So the DOC consultation model is...
Well, it's one that's been proposed by the Crown that starts before the consultation process, which means that for their planning frameworks, there is a pre-korero with those that are interested and those that are related to the kaupapa that needs to be dealt with. In experience, though, that has been poorly performed. It happened with the conservation management strategy and the way in which the conservation management strategy lacks the appreciation of the significance of the cultural landscape and the biological landscape that is around the Mōtiti Rohe Moana. But nonetheless, it's something better than no consultation.
Is there a sense in which the issues here are well understood, in the sense that it's been an issue since for 20 years, since the Ngāti Apa judgment and the original Foreshore and Seabed Act?
And sorry,
well, the overall issue is one that has been front of mind for 2 decades now, in terms of how to address the different interests, and Māori interests in particular, in the foreshore and seabed. And so does that colour consultation to some extent, and what consultation looks like?
The rohe is inherent. So the issue around the Crown now trying to take ownership over this rohe is an assault on our cultural understandings and our relationships to it. This is hence why we feel that this is a breach of our mana and our relationships in our rohe.
What's the sense in which you say the Crown is looking to take ownership?
Well, I think, did the Crown not say that, there was a position where the Crown owned the rohe, and now the position is no one owns the rohe, and then whatever the position will be in the future, from Māori or from our perspective, the rohe is the rohe that we have our cultural associations and relationships with, and that we have a grounding in our identity in that place. You're just washing over it with some new colonial structure doesn't alleviate the reality of that understanding.
Thank you. I understand. I don't have any further questions, Mr. Sayers. Thank you very much again for your evidence.
Kia ora.
the same phrase that Mr. Stevens asked you about, the perception that you had that the Crown, on your perception, was taking ownership. Is that in the context of, if you don't have CMT, resource consents will essentially utilise the area?
Aye, Tucker. This is our most concerning thing because of the experiences we've had with various authorities that have exercised, I suppose, resource consents of different forms, whether it be even fisheries, all the way through to coastal landings, other structures that may be placed in the coastal marine area without a clear recognition of what's appropriate in those places and without the transfer of that knowledge so that we all can do a better job around how we preserve the rohe. I mean, collectively, we must all be willing to look at means of preservation in order to, I suppose, enhance our experience.
And I take it the RENA experience would have sharpened your pencil about that.
Aye.
Thank you.
Thank you, Mr. Sayers. I don't have any questions for you, but thank you for your evidence.
Tamahi. Kia ora.
Ms. Evans?
Tēnā koe. I just have one part-time re-examination. My friend for the Crown asked you, Mr. Sayers, about the timing of the pending judgment that relates to CMT whangai te hapu. Would you like to elaborate or expand on the relevance or not of that pending judgment to the issues you and Ngai Te Hapu have with the Crown's proposed amendments?
Our concern is that we end up spending more wasted time, more wasted generations, without actually having the mechanisms to be able to see the recognition for the values and associations of our taonga, our tapu, our rohe, and being able to exercise the provisions, or at least assist in the provisions of any other authority that may want to provide a resource consent. At the moment, it's without CMT. We have had to go through very extensive litigation in order to achieve the recognition of the Mōtiti Rohe within the coastal planning frameworks, both in the Regional Coastal Policy Statement and also in the Coastal Management Plan, in which we preserved the awareness of our wāhi tapu, our wāhi taonga, and the other attributes that are within our customary landscape.
Tēnā koe, Mr. Sayers, koe e aku pātai tēnei wā, nō reira tēnei te mihi atu kia kaurua, mō tō mātauranga, nei rā te mihi anō. Tēnā koutou.
Kia ora. Ni te mea nō rai nei, I te aroha nō tupuna I tuku iho, I tuku iho. Hai, nā mihi, kia ora.
Sarah, I wonder if this isn't time for a micro break, if that might be appropriate while we sort the next witness.
I see Ms. Mason has just arrived, and we are running slightly ahead of time, Ms. Mason, but I understand your witness is...
Yes, she's here, so we can go on now if you prefer.
I'm in your hands. If you're ready to go now, then yes. We will make a start. Okay.
So is your name Moerangi Potiki?
It is.
And did you file a brief of evidence dated 8 August 2024 with the number A34? Yes, I did. And are the contents of that brief of evidence true and correct to the best of your knowledge? Yes, it is. Okay, Ms. Potiki, my friends from the Crown and the Tribunal have some questions for you, so if you could answer them, please.
Oh, tēnā koe, Ms. Potiki. I don't have many questions. You have given a brief of evidence dated 8 August 2024, that's A34, and you refer there to an application that was, like the witness before you, heard in 2021, and judgment still pending for that one.
That's correct.
And again, no particular reason for the delay?
No.
Are you able to speak to, assuming that the proposed amendments are put into effect, are you able to speak to the impacts that will occur in having to undertake a rehearing some years after the event, after the original hearing?
I would prefer just to say not at all, that I don't think it should take place, given that we have already given evidence, and that if we were to do it again, is that will just, from my point of view, just re-traumatise. That's how I feel.
Yeah. The other question that I've been asking is whether, if there is to be a rehearing, whether there is anything that might be done in terms of measures to decrease the trauma or mitigate the impacts.
I guess, again, that's quite a complex question, because we've already given evidence, and if that evidence is not appropriate, how much more would we need to do to make it appropriate?
Mm. Thank you. Those are actually all my questions, but I'm grateful for your evidence. Ngā mihi ki a koe.
Kia ora.
Tēnā koe, Ms. Potiki. We don't have questions for you, but thank you for the evidence you have given to us.
Ka pai.
Ms. Mason.
So no question.
No questions of re-examination, and the next witness will be on an AVL, so maybe we could do that after the break. Sir. Yep.
Yes, so thank you, Ms. Mason. So I see the next two witnesses are due to give evidence by AVL.
Yes, sir, both of them.
And we are running somewhat ahead of time. I'm aware that Mr. Araroa has already made arrangements to attend tomorrow. What about Mr. Crisp? Can I just check with Council for Mr. Crisp?
Sir, it's Ms. Irwin Easthope here. I don't want to speak for McCall Lewis or Ms. Siciliano, but I was talking to her over the weekend, and my understanding is that he has made arrangements to be here tomorrow as well, as has Ms. Siciliano.
Okay. Ms. Mason, just to clarify, are you suggesting that we take the afternoon break now?
Yes, sir, then we can organise the next witness. So we've just got two, and it depends on my friend's questions, but the break would be appreciated.
And so what time are you suggesting that we reconvene?
So we just need 10 minutes.
10 minutes. Okay. That's a relatively short break, so we'll take that as a micro break rather than perhaps the afternoon adjournment, just so that you can make arrangements, because I'm also aware that there may not be refreshments available at this time, but we'll take the break for 10 minutes so that you can make arrangements.
Yes, so 5 minutes should be fine. We just have to get a hold of him and make sure that he's got the ABL.
Okay. So we will take a short break. Ms Mason, if you can just liaise with the tribunal staff just to let us know how you are going, we'll reconvene once we're ready.
Yes, thank you, sir.
Kia ora koutou.
Wai nā te kōti, te pāremata raini, ko wai koutou ki te toha kia mātou ngā hapu o Ngāpuhi. So outside of that, fundamentally, that whole process seems to me upside down, where we've always had a relationship with taku taimwana. Actually, that's where majority of our engagements, mai rāno, as Ngāpuhi happened. I don't think actually the other side or treaty partner would be here if it wasn't for the taku taimwana where we had those major engagements. And so we've always known and had that history. So the belief is that actually outside of this box of the MACA, forcible seabed, now MACA, is actually that waiho mā ngā hapu me ngā rangatiratanga kei a tātou tera. Our involvement with the whāngarei case really stems from the position that our people are in. I don't think there's any any lawyer perhaps in that room who are not guilty of assimilating our people's whakaaro over and over and over again for many generations now, rightfully or wrongfully, but we continue to play in that system. And I feel for our people because that's not natural, that's not inherent to us. And when the whāngarei MACA hearings came about, the runanga was approached by claimants who came kanuhi ki te kanuhi to see myself and some of our trustees about giving awhi. Now, in a simple mind, a simple whakaaro, that's awhi, however that came about. All still continues to come about. The role of the runanga is to support all our hapu, all our people, and so when these particular claimants came in, we agreed to provide evidence from a iwi, and this is not the Pākehā concept of iwi, from a conglomerate or a confederation of hapu, and making sure that we are there to support, whether it's evidence-wise, kaumātua-wise, kōrero tuku iho. We agreed to participate and support those particular claimants. But fundamentally, as I mentioned, it's not something that should be happening in the first instance. So that's what we've done.
So when you say it's not something that should be happening in the first instance, I might have missed what your answer was in that regard, but what is it that you mean by that? What is it that shouldn't be happening in the first instance?
Well, again, I'll jump outside the box. Everything politically right now, everything and all of the turning over of the hard-fought legislations that we have fought for as Māori, this is the context. It shouldn't be happening in the first place. There should be the view of our hapu for Ngāpuhi, and our marae is actually kei a tātou, tō tātou mana mutuhake, kei a tātou, tō tātou rangatiratanga. So when you get the court process or a legislation process that will come in as it has done for a long time, we kind of skip some of our basics because of, as I said, the layers of assimilation, whether it's the right process, there's also a fear of missing out. There's a range of reasons why our people participate, but actually, and that's nonetheless the doing of the Crown. That shouldn't be happening. If it was under our tikanga, and I mean the tikanga which no one seems to be able to lock down from your side, but under our tikanga o te kāinga, it will, and it has, similar to many generations before, have some solution. So that's what I mean around it shouldn't be happening fundamentally in the first place. The actual hearings, the legislation, hoha haere tātou wei, we hoha about all of the overturning and stuff. And I've watched all of our mai kaumātua koe fight hard for that. So I know we're talking about the one kaupapa today, but we must never take it out of the context of everything else that's happening.
In your evidence, you say at paragraph 13 what the Crown is proposing to do interferes with what should rightfully be left for the courts to determine, namely the nature and extent of our customary title. The decision of the Court of Appeal in Re Edwards should be left alone, and Crown and Parliament should just stand back and let the court process continue. So you'll know that Re Edwards has been appealed to the Supreme Court, and the Crown is advancing the position there that the Court of Appeal's decision should be overturned in a manner that is largely or effectively the same as what the Crown is proposing to achieve by legislation. Are you saying that you are content for the Supreme Court to resolve the issue according to the existing legislation, and even though one outcome there might be that the Crown submissions might be accepted and the Court of Appeal decision be overturned?
I mean, I'll start off and say our title of the box again is both the court and legislation should step aside and actually waiho mā tātou tērā. And this is the case in point. Now, to actually help and support our people, we will jump to a court scenario and or whether Parliament enacts the changes or overturn. And that in itself has its challenges. So why I put that into my evidence was because it's that rock and the hard place. Let the courts do it in the matter of justice, because we know if it's left to politicians, it's left to that process in there, it becomes a population argument, 20% of the population. And we know that doesn't work for us. And so it's you're damned if you do, if you don't. And so that Supreme Court or the play out in the court is probably what settle for second best, because our first best, or our prominent position for Ngāpuhi especially, having not settled, having being the kaitiaki of te whakaputanga me te tiriti, is actually both, all of you stand aside. We know that's not going to happen because tāringa rahi ana te karona. So again, it's probably not a black and white answer, but koina taku whakautu.
I understand. I think what you're saying is that the courts as compared to Parliament, you have more confidence in that process, and your evidence is that Parliament essentially enforces the tyranny of the majority, and you don't see justice for Māori there. That's the essential point that you're making, if I understand it.
Yeah, I guess it is. I mean, and it needs to be raised, it needs to be said, because for this one kaupapa, this is what's happening in this scenario. In the many other kaupapa, that's what's happening. And I would even go so far to say, and I know this is separate to this kaupapa, but, you know, when are we going to push back on all of these changes and hard-fought changes of our people, our kaumata kuia? And actually, if it's so easy for Goldsmith, it's so easy for the Prime Minister to say the other day, we don't have sovereignty, well then that is it, that is hoha haere from Ngāpuhi's perspective. Actually, I will say, I'll organise some hapu, and at least my hapu anyway, and come and say that to Ngāpuhi hapu. I'll even go so far to say, so that whoever can hear it, is actually if it's so easy to turn down the, dial back all of the legislation that we've worked hard for, I would encourage any of our Ngāpuhi hapu, we all know that settlement process is 1 cent to the dollar. Why don't we go for the dollar if ever it was reconciliation? Actually, furthermore, why don't all those who have settled full and final, change all of our whakaaro around the law and open up historical settlements? Everyone go for the dollar. Koina noi ho. I know time is short, so I'll just cut to the chase. Hoha haere katoa.
I don't have any further questions, Mr. Tahiri, but ngā mihi a koe, kia ora.
Tēnā koe, Mr. Tahiri. We don't have questions for you, but thank you for the evidence you presented to us today. Tēnā koe.
Tēnā tātou.
Sir, just before we go to the next witness, I just wanted to raise a concern about
questions from my friend for the Crown. This is a sort of a suggested equivalence in the questions between a rehearing after the Supreme Court or further submissions after the Supreme Court makes its decision and the Crown's proposal, which we don't even have wording for yet, but we know wants to cut down the CMT that exists that can be issued to some 5% of the coast. Those are very different propositions, they're very different processes. They may have some similarities, but I think it's unfair to put to witnesses a proposal that, well, there'll be some sort of rehearing. I think if those questions are going to be put, they need to be, the nature of those two propositions needs to be made clear to the witness. That's the concern, sir.
I understood the thrust of the questions from the Crown was really around whether the claimants have suggestions on how the impacts or prejudice from that rehearing process could be mitigated. It seems to me that that has been the focus of the Crown questions, rather than
Yes,
drawing a similarity that a rehearing in one form is a rehearing in another form.
Yes, I just thought I heard a question that said that there was some similarity between those processes, and that's the concern, that if claimants are being led to believe that, you know, there is that equivalence, they're answering sort of the similar question. There's going to be a rehearing of some kind either way, and they're sort of equivalent things in some sense.
Mr. Stevens?
It's impossible to really know the extent of the equivalence. What I'm postulating with that question when I've put it is that one outcome in the Supreme Court in Edwards is rehearings of some sort, depending on what the Supreme Court decides. And for example, in Edwards itself, the Court of Appeal has directed 3 rehearings that are in abeyance until the Supreme Court rules. But my friend Mr. Benyon is of course right to say that there isn't a direct equivalence. They're rehearings of some sort, and the scope and the nature of them is dependent on the test, and it's dependent on what the Supreme Court might do. And so I don't want to be taken to be suggesting that merely because the Supreme Court, if the Supreme Court is just left to resolve Edwards, then that is the same as the proposed legislation. I'm not suggesting that, and I couldn't suggest that. But there is the prospect of a rehearing of some sort for some cases, dependent highly on what it is that the Supreme Court rules. And but I can't suggest that there's any more equivalence than that. And I'm not suggesting that they would be the same in terms of impact or cost. And then, of course, Ms. Rumpt had suggested that one is different in kind from the other in terms of the claimant's attitude and experience and involvement in the process. So I hope that clarifies the Crown's position. Thank you, sir.
Thank you, Mr. Stevens. Ms. Mason.
Mr. Clendon, can you hear me?
Can.
Okay. Now, can you... Tēnā koe. Can you just confirm for the tribunal that your name is Matu Taira Tenano Clendon?
Yes, kia ora, that's correct.
And that you have filed a brief of evidence dated 8 August 2024 with the number A37?
Yes, tika.
And that the contents of that brief of evidence are true and correct to the best of your knowledge?
That's correct.
Now, Mr. Clendon, can you please answer some questions from my friends, the lawyers for the Crown, and then from the tribunal? Thank you.
Okay.
Oh, tēnā koe, Mr. Clendon. Can you hear me?
I can hear you.
I have just one question. well, first of all, let me say I understand your evidence about what you say the effect of the proposed amendments will be, and acknowledge that. I just wanted to clarify the nature of your claim, your interest in a MACA application. And your claim, as I understand it, is brought on behalf of yourself, some others, your whānau, and the hapu of Ngāti Kuta ki te Tairāwhiti. And you explain in your evidence that Ngāti Kuta share ahika at Te Rāwhiti with Pātukehea, and that the two hapu are distinct and autonomous, even though the rohe they exercise rangatiratanga and mana over is shared. Am I right to say that the MACA application brought by Ngāti Kuta and Pātukehea ki te Rāwhiti is the named claimant for that is Jamie Hurakino Hakaraya? Am I right about that?
Oh, Jamie did, yes.
So
And, hang on. If it's on there, you.
So it's he will be he's the named claimant for the MACA application for the two hapu.
Well, it was yeah, Jamie, yes, Jamie and
Just Jamie.
Jamie, yes. Is it Jamie Patkea or is it Jamie Patkea Ngāti Kuta? Which one? Both.
It's for both, I think. Yeah,
Correct.
is my understanding. I just wanted to check that with you. And otherwise, I've read your evidence. I wish to acknowledge it, and thank you for giving evidence in the tribunal on this matter. Kia ora.
Kia ora. Oh, that's it.
Kia ora matua. We don't have questions for you, but again, I just want to acknowledge you for the evidence you've presented both in writing and for taking the time to appear before us today via AVL. Tēnā koe.
Tēnā koe te kai whakawā me tō rōpu. Tēnā koe.
So there's a waiata that's being sung.
Right?
Te ka mature e, te ka rawa au e, me pehea, te whakapono, me pehea, te mamai, me pehea, te aroha, mai ngā kōrero tuku iho e. Ko tēnei te whakautu e te korona, pera i te toke hau, ka hore hore kau, pēnei te rangatira, tuake tonu hau, ko ka witi hongi hika, e hoa tira rau. Pō mare tū haia, rua peka peka rau, whakahokia whenua mai, tangata whenua ki te pai, kranga mai te tupuna, ki a koe te krona. Ina mutu koe, kua mutu hoki au. He mihara, ho ho, te rongo, mana motu hake, tu tonu au e, whakahokia mai, ngāti noa tonga, me ngāti kanga e, o te reo rangatira, me pehea, te whakautu me pehea, te whakahoki me pehea, te whakatika ma te aroha miharo.
Tēnā koe reo.
Tēnā koe, sir. That's all of the witnesses that we have. Thank you.
Thank you. Mr. Lyle, we are now well ahead of time, which is always positive. Is there anything else that we can do to make use of the remaining time today?
Your Honour, I've been racking my brains, but I think possibly the best use of the time available would be for Claimant Counsel to go and work feverishly on our closing submissions in the time available, if Your Honour pleases.
Mr. Stevens? Okay. Thank you, Counsel. I just want to acknowledge you all for the hard work you've put in today, and also for all of our witnesses who have both attended and answered questions from Crown Counsel and from us as well. Ka nui te mihi ki a koutou katoa. We will finish early for the day, and I'll hand it back to our tohunga on my right, who will close the proceedings for the day.
Kia karaki a tātou. Tīkina atura. Unuhia te pūtake o ngā kōrero o te wānanga unuhia rā te hautapu o Ngāriki. Whakairia e rangi ki ngā pātu o te whare ko whakamau kia tīna hui e. Ai ki e. Very good.